Here you go, first time visit to the appellate. You are here, and your attendance shall be heard. Please be seated.
Good afternoon and welcome to the Appellate Division First Department. There is more than 7.5 hours of argument time requested, which would keep us here longer than I'm sure any of you want to be here. So I'm going to ask you to request only that time that you actually need, not the time that you want, understanding that the court is familiar with your case, the record, the briefs, and often more times than you wish we were. So understand that the time is for you, not for the court, so that if your arguments are brilliant and my colleagues have more questions to ask, I let the clock run, okay? So please, again, ask for that time that you need, not what you want, so that I don't have to cut your time off. All right. People versus Truelove. 5 and 1 and 5, thank you. 23 East 39th Street versus 23 East 39th Street developers.
Respondent, 7 minutes, please.
Okay. 5 and 2 and 6. M. Milani is a submit. Wilmington Savings versus Milani.
Appellant requests 5 minutes and reserve 1 for rebuttal.
Okay.
5 minutes for the respondent, please.
5 and 1 and 5. Thank you, gentlemen. Gellis versus Salvage.
Appellant requests 5 minutes and 1 minute for rebuttal.
Okay.
Respondent requests 5 minutes, sir.
5 and 1 and 5. Thank you. People versus Dwayne Affleck. Okay.
People request 4 minutes, Your Honor.
4 and 1 and 4. David, People versus David Kamara. Submit. HSBC Bank versus Nomura Credit and Nomura Home Equity versus Nomura Credit. We're going to be listening to those arguments together. Gentlemen, your request? No, together. We're going to argue these together. So how much time? Because the issues are the same.
It's just that we're responding on the second.
I understand. How much time would you like?
Total of 7 minutes and 3 for rebuttal.
Okay?
7 minutes, Your Honor. One thing, Your Honor, just to be clear, we are splitting the arguments, myself and my colleague.
Okay, so of those 7 minutes, how much time are you splitting? 3.5 and 3.5? Okay, so 6 and 2, 4 and 4. Okay? Inano versus Silverstein Galaxy.
Good afternoon. The appellants are requesting 5 minutes and 2 minutes for rebuttal, please.
Okay? 5 and 2 and 5. E. Joselyn versus Carl R. No. Give me a more reasonable time. 4 and 1 and 2. Jobar Holding Corp versus Halio. Okay, you have a cross appeal? Okay, so you get 5 and 1, and you'll get 4. 5 and 1 and 4. People versus Robert Dancy. Okay. 5 and 1 and 6. Brazil versus New York State Office of People with Disabilities. Okay. 6 and 2 and 6. Edwards versus Rockland Hospital.
Plaintiff requests 5 minutes and 2 minutes.
Okay,
Respondent Rockland requests 3 minutes.
okay.
Respondent, he goes 5 minutes now.
All right, 5 and 2, 3 and 3. People versus Jose Luperon. Submitted. Lee versus I'm sorry. Okay, 4 minutes for appellant, and there being no respondent, 0. Lee versus Grimalt. That's you, okay. All right, I'm gonna give you 3 minutes, and if my colleagues have additional questions, then it'll go over that. Masaryk Towers versus New York State Division of Human Rights.
Good afternoon for the appellants, Your Honor. This morning, counsel for the state, the respondent advised that she wouldn't be able to make it because she's sick and she'd like to be on submission, and we don't oppose that.
That's fine, submitted. Thank you. People versus Derek Velasquez. That's a submit. C3 Data versus 212 Media Group is a submit. First case on the calendar is People versus David Truelove.
Good afternoon. I'm Catherine Martone on behalf of Mr. Truelove. The search warrant in this case is defective on its face for the same reasons as the Court of Appeals controlling authority, People v. Rainey. The warrant violates the federal and state constitutional requirement that no warrant shall issue unless it particularly describes the place to be searched. In Rainey, although the address consisted of 2 residential apartments, the warrant failed to designate the residence for which probable cause existed.
Did the warrant not specify the color of the door? And if so, why isn't that with sufficient particularity?
Okay, so the warrant did specify the color of a door, but
It also specified the location, right? The first door to the right?
so the warrant specified an address, 955 Bruckner Boulevard, first floor apartment. The warrant described the door of the bedroom inside the apartment as tan and unmarked.
There's no question that the informant got it wrong in terms of describing what these doors were. But was there
Okay.
2 tan doors so that there would have been certainly a question as to which tan door was the right tan door?
Okay, so Your Honor, I think the doors were white, but that's exactly the issue. There were 2 doors.
The other door was white and one was tan. And the search warrant and the informant said that it was the tan door where there was a gun in the premises, correct?
Okay, Your Honor. No, that's not correct. The search warrant directed the officers to the first floor apartment at that address. And then the warrant
Were there more
states-
than 1 apartment on that first floor?
Yes, that was established on the defense's uncontroverted motion to suppress the evidence for the facial insufficiency of the warrant. The
But one
defense-
door was tanned and the other one was marked.
Your Honor, the warrant describes a door.
Is that accurate? That there was one door? Look,
No,
I understand.
Not accurate, Your Honor.
Counsel, let me finish my statement, please.
Yes.
I understand that there were clearly inaccuracies in the informant's information.
Yes.
In terms of he clearly or she clearly mistook the vestibule door for one of the relevant doors. I get it. But inside, once they get past the vestibule door and they go to the right, there is indeed a tan door. The only other door is down a hallway by a staircase, and it is white and marked. So explain to me how that would have caused some confusion in the officers who were executing this search warrant and who were looking for a tan door, and based on the evidence I see, correct me if I'm wrong, there's only one tan door.
Okay, Your Honor, I think you are wrong. And I have the photos that were submitted on the defense's motion. I have copies of them here. I believe that the photos show 2 white doors, but put aside the question of.
So you say there's no tan door?
There's no tan door, and I also say that the door that the prosecutor is claiming was the targeted apartment is marked with a letter 1. And the warrant directed the officers to an unmarked
The
door.
tan door in question had no marking. The white door had the marking of 1.
Judge, no. The door in the photos submitted on the defense's application show that the door that is the targeted apartment, the apartment for which probable cause existed, has.
Which was the tan door, according to the statements to the judge at the in-camera search warrant application. That the statements there were about a tan door.
Tan door that was inside of an apartment.
Right.
The tan door was supposed to be the door to the bedroom that was inside of an apartment. Okay,
I got that.
you can see from these photos that there are 2 apartments on the ground floor.
I see one door in the picture you're showing
See,
me.
that door has a number 1 on it. The office.
But that's one door. So where's the other door?
The other door is here, and it's unmarked, and that's the neighbor's door. That's the problem with this warrant, Your Honor.
Wait a minute, so the door they went into was the marked door with the 1 on it and not the tan door with nothing on it?
This door has nothing on it. That's the neighbor's apartment, and this is why the warrant violates the Constitution. This neighbor had a right to be secure in her home.
Are the colors of the doors the same, the
I think
external doors?
The colors of the door are the same, Your Honor, and if you look at the photos that are submitted on the
On black and white photographs, we cannot discern the difference. Counsel?
Sorry, Your Honor, I see my red light is on. And
Yeah, but it's beyond the red light problem. It's that you are talking when I am talking,
Yes.
and that's a problem. But you'll have time on rebuttal.
Yes, but the photos submitted.
You'll have time on rebuttal. Thank you.
Good afternoon, Your Honors. May it please the court. I'm Amir Kedmati for the respondent. Your Honors, if I may, I'll just say a few words about the appeal waiver before I get
No,
to it.
why don't you just talk about the warrant? Because obviously that's the issue here.
Sounds good, Your Honor. As to the warrant, I'll just have to note initially that the defendant did not establish that there are 2...
Counsel,
Yes, Your Honor.
I need you to focus on what we've been talking about.
Yes.
There's a serious problem here, and I'm sure even you can appreciate that your informant gave some bad information, okay? Thank you. They described the first door as an apartment door when it was the vestibule door. So we have a problem here, and I need you to be on the same page as that.
Yes.
Let's not pretend like that's not the case, okay?
That's correct.
All right, so now proceed on explaining to me how this very flawed description satisfies constitutional scrutiny.
Yes, Your Honor. Your Honor, the warrant authorized the search of a single bedroom on the
No.
The
first...
warrant authorized the search of a first-floor apartment.
Your-
First bedroom on the right, tan door, not marked.
Yes.
Right? But it specifically says first-floor apartment. If there are, in fact, 2 apartments on this first floor, how is this warrant sufficient in terms of particularity?
But Your Honor, that's the point I was trying to allude to. The defendant did not raise a material issue of facts that there is indeed 2 apartments on the first floor. They simply submitted 5 photographs along with an affirmation from a legal aid investigator. But that's not enough to say that there are indeed 2 apartments on the first floor. The only information we
What we know, though, is that the search warrant talks about the first door, and we know that that first door, your informant got it wrong. That first door wasn't the apartment door. That first door was the vestibule door. So from the inception, your informant got it wrong. So now the issue we are grappling with is whether the police officers had enough, based on what was present, to make us have confidence that there wasn't a mistake here.
Yes.
So explain to me how this very flawed description by your informant, can we agree it's flawed, or are we having a separate conversation?
I agree that it is possible that the description.
No, not that it's possible. He describes the first door as the apartment, and it's the vestibule. How can you say that it's possible that there's a problem?
What type of building is it? Is it a tenement apartment building or is it a house?
It's a multi-story apartment building.
Okay.
Yes.
So the first door is described as the door of, the vestibule door is the door of the apartment.
It's possible that the CI described the building's entrance door, the vestibule door, as the apartment door, and described the apartment door as the bedroom door.
How is that okay?
No, I understand. I still think there was enough a description in the bedroom to be searched that even with that mistake, and I cited.
Well, counsel, I mean, I don't know if you're following along with our questions here, because you can't even get to your point of the inside the bedroom if you can't get into the apartment with sufficient particularity, and that's the problem here.
Well,
What does the warrant say to search?
The warrant says 955 Bruckner Boulevard, first floor apartment, first bedroom on the right.
First floor apartment, singular.
Yes.
So it sounds like the warrant is operating, the warrant was drafted and signed under the assumption there was only one apartment on the first floor.
Yes, Your Honor. And based on the information that we have, there is only one apartment.
That's incorrect.
But, Your Honor, the only...
That is incorrect based on the record before us. So you are asking us to ignore the record we have and to pretend like that second door, the white door, with the marking isn't a separate apartment.
Right.
Your Honor,
because
only
counsel, when you go into that first door, you don't enter into an apartment. You enter into a vestibule. You enter into a hallway. So that eliminates your theory that that's an apartment that you've entered.
Well, what I'm trying to say is that we don't know whether those 2 doors on the first floor lead to the same apartment.
But now we're getting into People versus Brown, where the officer has to use discretion to choose which door to open to attempt to find the bedroom with the tan door. Isn't that the position now the officers are in, that they have to use discretion to decide which door, 1, 2, 3, 4, 5, however many there were, to access to look for the tan bedroom door?
Well, if it is the case that both doors led to the same apartment, then I believe there was enough on the face of
You're not hearing us at all. There were 2 apartments. There were 2 apartments.
Can I say something about that, Your Honor? Defendant cites to People v. Duval, the Court of Appeals case, where the court upheld the warrant despite the fact that the defendant provided much stronger evidence, much stronger documentations of the fact that the unit was 3 separate.
There wasn't a
residential
hearing,
units.
there wasn't a Darden hearing here, right?
There wasn't a hearing here.
Right?
No, a map hearing was ordered, but the defendant suspended fact-finding by taking the plea.
Okay, but the Darden hearing was denied
Was denied.
by the court. And what would be the purpose of the Darden hearing?
Uh,
Would that not involve the search warrant and everything that we're talking about here?
But that information would still come out in the map hearing, Your Honor. Because this
Not necessarily.
I mean,
Wouldn't part of the hope here be under the Fourth Amendment that there's some predictability? And so the officers, again, neither the officers nor courts who are asked to controvert a search warrant have to engage in any sort of guesswork?
That's correct, Your Honor, but I believe that, like I was trying to explain earlier, we don't know if the officers had to engage in
I
guesswork.
wonder if we could find that out at the Darden hearing.
That's the point. We don't know, counsel. We don't know. That's the point.
Well, if that's and it may, you're absolutely right, Your Honor. Maybe a hearing would have been helpful. So in this case, I would say that the proper remedy here is not a flat vacature of the conviction. It would be perhaps to remand to the lower court to engage in further fact finding to ascertain whether or not there was indeed multiple apartments on the first floor. And I was just, if I just may very brief.
You have 30 seconds, because I cut off your adversary, so you got 30 seconds.
I understand. I just want to say that if there was indeed multiple apartments on the first floor, defendant could have supplied more information. The investigator, for example, could have
I'm
photographed
sorry,
mailboxes.
you have the obligation, not them.
The burden's on you, counsel. The burden's on the people.
Thank you.
Thank you, Your Honors.
And I will give you an extra 30 seconds, okay?
Your Honor, the point, the problem here is that the district attorney's office did not controvert any of the facts that the defense submitted on the motion. So the defense submitted the photographs and the affidavit of the defense investigator. The district attorney did not refute those allegations. The defense investigator sworn statement says that there are 2 residences on the first floor of that location, and the district attorney's office didn't contest the allegations, the accuracy of the photos. They didn't even join
Does the investigator's affidavit say that both doors are white?
Your Honor, I don't believe it states that both doors are white, but I would like to point out that on the district attorney submitted as an appendix or as exhibits to his brief, photos of the scene taken by the investigator that are in color. And so the court can tell for itself, those doors are both.
But what difference would it make what colors the doors to the apartments were? Because the warrant doesn't specify a color of an exterior door to an apartment. It specifies the color of a door to a bedroom within an apartment.
I agree with that 1,000%, Your Honor. I'm just trying to address the district attorney's argument to save the facial validity of the warrant. I'm saying even that argument doesn't make sense based on the facts.
Thank you. Thank you. 23 East 39th versus 23 East 39th Street developers. You may proceed.
Thank you, Your Honor. May it please the court, Stephan Kalina for the appellant. Your Honors, the judgment here in the case, we argue, must be vacated and either modified by this court or remanded to the Supreme Court because the summary judgment determination in 2011 on the counterclaim as pleaded controls the case. And by virtue of the judgment not referring or reciting to the actual issues or determinations made by this court, it leaves open by omission the opportunity for the respondents to have commenced a lawsuit in a different county, separate department, on a theory that is diametrically opposed to that which they pleaded in the case in the New York County Supreme Court, on which Judge Lincoln issued a summary judgment decision and affirmed by this court. And I'd like to make it perfectly clear that the nature of this appeal is not to relitigate that aspect of the litigation. The nature of this appeal is just to simply ensure that the judgment reflects those determinations because the action that has been commenced out in Nassau County and as was seen by the...
Is it proper to include findings of facts in a judgment?
As a matter, yeah, well, Your Honor, I would answer it this way. A judgment can reflect that which is necessary to refer to the determinations. Here, the judgment refers only to the referee's hearings, and it does not go back far enough.
You didn't answer the question.
So the judgment need not necessarily refer to specific factual findings or legal conclusions, but the issue that was brought on or heard to be determined should at least be referenced. And there's no reference at all to the 2011 Supreme Court decision or the affirmance. It's an almost disembodied reference to a referee's hearing on damages, and that disconnect to leave open would exalt form over function when one reads the Second Department decision. It does not comport with the 2011 decision and the 2015 affirmance based on the only evidence on the counterclaim that the respondent sought in the Supreme Court.
Counsel, essentially, what you'd like to have is some sort of written order that indicates the last date for which rent was owed, right?
That would reference not so much, Your Honor, that the rent date was owed, but that the lease was terminated such that was the last
Why
date
in
that
all
rent
of
was
these
owed.
years
The judgment doesn't require
Right,
that.
and why in all of these years of the litigation that this case has been pending, did you not seek some further clarification of a prior Supreme Court order that would indicate that fact?
So, Your Honor, the appellants here are the net creditor under the judgment. We recognize that it's an aged case. However, it wasn't until the action was commenced in the Supreme Court in Nassau County did the issue in the judgment really come into stark relief. And there were applications at that immediate juncture. At that point, the appellants were the net creditor of an insolvent entity. They were entitled to the money. And it was understood by the contemporaneous understanding of the parties, the evidence before the court, and we submit the judge exactly what was being decided. That this was a lease that terminated in January of 2009, says the Supreme Court, even though, of course, the appellants then had argued it was a 12-month tenancy. But that is a settled matter. And at that juncture, the Supreme Court issued its decision. There was an appeal. And as I've mentioned before, we're the net creditor. It does not change the fact that the summary judgment determination on the sworn pleading, on the counterclaim that the respondents actually requested the court to search and find in their favor, is now, by omission in the judgment, being the respondents have taken that opportunity and gone to another county and pleaded the exact opposite.
But what you're asking for is not something that should be included in a final judgment. Is that not correct?
Well, then, Your Honor, then the judgment should be vacated and perhaps remanded, Your Honor suggested, for an order, remanded back to the Supreme Court for
I
further.
didn't suggest anything.
Well, then
That's
I
what you're
apologize.
suggesting.
We apologize. Our appeal
And that's why we're here.
requests two forms of relief, either vacature and modification by this court, or
But you haven't
vacature.
given us a reason, legal or otherwise, to do that. So let's send it back because it doesn't have the language we want?
No.
Yes, that's exactly what you're arguing.
We are arguing that the judgment on its face does not reflect or even refer to the determinations as pleaded.
It doesn't have to. That's the point. You'll have time on rebuttal. Thank you. Counsel?
Good afternoon. The scope and extent of the lower court's 2011 order was already considered and determined by the Second Department. We recognize that the principle of comity does not impose an absolute obligation, but it is more than just a matter of goodwill or courtesy. Comity exists as a concept because relitigating issues that have already been fully and fairly adjudicated is not a good policy. I respectfully suggest that the courts in this state have enough work to do.
On that, we agree.
In 2015, when this court entered its decision in the prior appeal, at that point, the issues in this case were effectively resolved. All that was left was a need to calculate damages, and the parties would subsequently stipulate to that without controversy. Appellant elected not to return to this court to prosecute what they thought would result in an uncollectible judgment. It wasn't, and the case was marked inactive. It wasn't until 4 years later, 2019, that they returned to the lower court specifically because they were unhappy with what the Second Department had done. They were not interested in obtaining their uncollectible judgment. They wanted the lower court to serve as a court of appeal and overrule the Second Department. And that's what they want this court to do now. Enough judicial resources have already been wasted, and if this case gets remanded or the appeal is granted, it's going to continue for years. I have this nightmare where I'm standing in front of the Second Department arguing in front of them that this court made a mistake by overruling their decision.
We don't make mistakes.
I'm sure the second department feels the same way. The point is that circumstance is insane, and it's something that I don't even want to think about. There was some sparring in the briefs about what was in the record for the second department. The second department, and there's no dispute, the second department had the pleadings in this case. What appellant is now categorizing as judicial admissions were presented to that court. They're in the briefs. They were argued to that court. That court also had the lower court, in this case's 2011 order. It scrutinized it. It made a determination. The simple fact is that the issue here now is this issue of the surrender declaration and the validity of the surrender declaration. That's what was decided. The initial part of this case had nothing to do with the surrender declaration. Everyone was arguing about whether the previous notice to vacate was valid or not. The surrender declaration didn't come up until the case in Nassau County started, and that was the issue in that case. That was the issue that the second department considered. I'd also like to say, with respect to the evidence, the factual assertions that have been presented, appellants repeatedly, after they came back in 2019, made a host of factual assertions in affidavits and letters, et cetera, et cetera. We steadfastly argued that those assertions were untimely and improper, and the courts below agreed with us every time. We had no occasion to rebut those allegations because we didn't have to. It's akin to having a witness testify, objecting on the grounds of hearsay, having the objection sustained, and then going to the appellate division and your adversary arguing that that testimony is unrebutted. It's unjust, and it's not for this court, respectfully, to make findings of fact in the first instance, and particularly in a case like this, where the evidence was never accepted in the first place. I'd also like to point out one other thing. In appellant's reply brief, page 16, they make a note that they don't characterize their previous submissions to the lower court as motions to renew and re-argue. They characterize them as motions for clarification. No appeal lies from a motion to clarify, and that's Fresco v. 157 East 72nd Street, Condominium, 2AD3D 326, First Department, 2003. Unless the panel has any more questions.
Thank you.
Thank you.
Counsel, you have 2 minutes.
Thank you, Your Honor. And I understand the court is pressed for time, so I want to address one key thing that my adversary has mentioned. He said to this court, the surrender declaration did not come up until the Nassau Supreme Court in the subsequent case. That is flatly incorrect. It belies the record. Our appeal is premised solely on the fact that they pleaded in the New York County Supreme Court in 3 ad seriatim paragraphs. They cite the termination provision of the lease. They cite the surrender declaration, and by their express language say, by reason of the surrender declaration, rent is therefore, they remain liable for 3 more months. That's their express pleading. And when they asked the Supreme Court to search the record on summary judgment, the only evidence was that sworn pleading. So when my adversary...
Well, that and the fact that there was no notice that was rendered 90 days before the termination.
Respectfully, Your Honor.
As was required by the agreement.
I think that factual confusion is what brings this appeal to
I'm
this
not
court now.
confused.
Well, we believe, and let me just answer the question directly. The initial notice in May was not the document on which the respondents relied to terminate the lease. Whether it's a factor under the guarantee is a separate matter, but if you look, Your Honor, at the very paragraphs that they plead, they cite the termination provision, they accept the surrender declaration as the notice to terminate the lease. That's their reliance. That's not a manufactured fact. That is what they swore to. the counterclaim is all of 3-4 paragraphs, and it goes from the termination provision to the declaration to the causal connective tissue. By reason of that declaration, they remain liable. The only dispute in the Supreme Court was whether there was 12 months of rent owed or 15. And to your
Thank
Honor's
you.
question, thank you, Your Honor.
Thank you. Wilmington Savings versus Milani. Wait for your colleague, and then you can start. You may proceed.
Good afternoon, and may it please the court. John Brigandy for the plaintiff. Plaintiff is respectfully submitting that the trial court's decision finding that the instant mortgage loan was time barred is erroneous. As set forth in our briefs, the trial court determined that the 2019 foreclosure action was dismissed for lack of prosecution. This is a factual-based error. On this factual-based error, the court determined that CPLR 205A was inapplicable to the present matter because the present matter was filed following dismissal for an action that had been dismissed for lack of prosecution, when in actuality, the 2019 action was dismissed based upon RPA APL 1304, as the 90-day notices did not comply with the case law at the time, which was Bank of America versus Kessler out of the Second Department. During the pendency of the instant action, the Court of Appeals actually overturned that decision, but that's irrelevant for purposes of this appeal, as this appeal solely deals with one issue, and that's whether CPLR 205A is applicable to Wilmington Savings. And plaintiff submits that it is. Not only was the 2019 action dismissed for failure to comply with RPAPL 1304, it is the same plaintiff in both the 2019 action and the instant action.
And that just brings me, I guess, to a question. We're talking about 205A and not 205-A, right?
We are talking about 205A, not dash A, and I would indulge your honors in a discussion about dash A, the Foreclosure Prevention Act. However, I don't believe it's relevant for purposes of the instant discussion.
Okay. You can continue, you still have time.
Unless your honors have any further questions, particularly about the application of FAPA, which I'd be more than happy to
We'll save your
discuss.
time on rebuttal.
Thank you.
Okay?
Good afternoon, Your Honors. May it please the court. I'm sure you've read the brief, and there's something missing from this case, which is a 2011 action, which completely changes the application.
But was that raised below?
I didn't know about it. The plaintiff made a representation in its complaint, and I believe that's in the brief, that there were only two prior actions, a 2011, a 2013, I'm sorry, a 2013 and a 2019. There is, in fact, a 2011 action, which the plaintiff does not dispute. Before Justice Kahn, while I was drafting the respondent's brief, I made a motion once I discovered, which was immediate. I contacted Mr. Brigandy, who I've known for probably a better part of a decade.
Why would you not have known about the 2011 action? Was that action brought under different names such that a search would not have revealed them with due diligence?
Well, I actually found it by accident. I was doing a name search under my client to make sure. I didn't come to this case initially.
I'm not blaming you personally,
I understand.
right?
But there was,
Please don't take it that way.
there was a 2013 action, which was the subject of a default. That was dismissed for under 3215C.
Right.
2019 action was dismissed under Kessler, which was later reversed by the Court of Appeals. Then this action was commenced in a timely fashion if the 2019 action was in fact timely. The 2011 action, which changes everything. The plaintiff has.
But my question was the caption on that 2011 action similar, the same?
No.
Such that due diligence should have revealed it so that typically we don't expect the other side to give us information that hurts them. So it's stuff that you have to find on your own.
Well, that's 100% true, Your Honor, but also, when an attorney makes a representation that there are two prior actions, 2013 and 2019, and there
That
was-
may be what he was told. I don't know. My question is whether there was due diligence exercised such that not finding the 2011 can be excused.
I personally searched the caption Wilmington and Milne, and the way I found it was while I was drafting the respondent's brief, and I said, "Oh my God, there's a 2011 action, and this is what."
So counsel, you in fact were able to find it, right? You found that there was this other action, right?
Yeah, well, it's a matter of public record.
Exactly.
That's my point.
Now, the fact that you found it, though, means that it was available to be found. It is a public record, as you just said. But what do we have before us to say the basis for which that action was dismissed or terminated? What information, factual information, do we have?
In the respondent's brief, make it very clear that the reason I actually said something about this, I don't even know if it changes the facts. I believe it might. But what do we have? But what do you have before? You have the public record, and this court may take judicial notice of a prior action, even if it's raised for the first time here.
Just because it was a prior, I'm sorry, go ahead.
Oh, no, I think we're going to ask the same question.
Just because it was a prior action, that doesn't mean that we know the reason for which that action was terminated or dismissed.
As a matter of fact, Your Honor, I looked into that, and there's nothing there except a complaint. So technically, it's still open. There's nothing in that action except a complaint. So in terms of looking it up,
I don't know. What is it that you're proposing that we do then?
let me just add one thing. So when I looked on,
No. What are you proposing we do with a 2011 action that you don't have any answers for? And what are we supposed to do? A fact-finding as the appellate court to determine whether there's an out for you on this case? That's not what we do.
I understand, Your Honor.
Okay, so I'm trying to understand your argument.
What are we taking judicial notice of? The fact that there is an action and a complaint?
That's it. That there was an acceleration in
For what? What's the
2011.
legal import of us doing that?
Because if there is in fact an acceleration in 2011,
But we don't have any
We don't
facts.
have that.
We don't have
And we
any
don't know
facts.
what happened with that. That it could have been dismissed or for
You
whatever
want
reason,
us
we
to
don't
do
know.
our own fact-finding into what happened in 2011 by searching through the court system's electronic records?
no.
So I gather what you want us to do is say there was by virtue of the action being brought in 2011, the debt and the complaint will contain an allegation that the debt was accelerated.
Correct.
And then that case is still on the vine somewhere, but 6 years has passed since the acceleration, and therefore any action brought after some period of time in 2017 would be time barred.
Well, I would love to be able to answer that. The answer is I don't know. And the truth is this court doesn't know.
So the best if we gave you everything we possibly could and we take judicial notice of that complaint, that still doesn't move the needle in a material direction, though, for you, does it? Because we would have to take judicial notice of a host of other things.
Your Honor.
And maybe ignore the fact that it's been pending since 2011 without any action, and then it maybe was abandoned.
Listen, it's very, very unusual that a respondent comes before a panel and says, please don't affirm. And don't affirm because the lower court got the facts wrong because of a misrepresentation by the plaintiff, which may or may not help them. All I have to do as an attorney, the first thing is once I found out about this, I had to put the plaintiff on notice, and it was put on notice by way of a motion. Justice Kahn properly, and he just decided it Friday, the decision was entered in NICEF on Friday, said, I can't, no matter what you say, it doesn't give me grounds to change the decision. So in other words, as the respondent and the...
So then you want us to reverse, is that what you're saying?
No, I don't want you to reverse. I want you to send it back so next time this thing comes up here, you at least have the right facts before you. So I'm okay, and if this were me, and I'm not saying Mr. Burgandy could or could not do this, but I understand why he did not. If it was me, I would have withdrawn the appeal.
All right, thank you, thank you. You got 2 minutes.
Respectfully, I'll be very quick here. The 2011 action, as set forth in the respondent's brief, is J.P. Morgan Chase Bank versus William Mill. Had that been searched by counsel at the inception of the instant action, it should have turned up. What occurred following my reply brief in this appeal being filed was that counsel filed a motion to renew before the trial court concerning the 2011 action. We were able to submit, plaintiff was able to submit proofs, including multiple title reports, payment history, and an affirmation from the counsel in that 2011 action.
How did you miss that there was a 2011 action?
I don't know specifically. However, I do know that the 2 title reports that were run, and they were provided to Justice Kahn in this motion to renew I'm referring to, did not include the 2011 foreclosure
Did the
action.
2011 complaint have the effect of accelerating the debt?
I do not remember. I would assume it would, because most complaints do.
Okay,
However,
so right. I think our law is
I
such
don't have
that-
it specifically in front of me at the
I
moment.
think our law is such that generally the commencement of an action does mark the acceleration of the debt. And
That
so
is why I'm
now,
agreeing, yes.
was the debt ever de-accelerated?
Yes, it was de-accelerated at the time that the affirmation in support of the motion to discontinue was filed, because
On which action?
in the 2011 action,
Okay.
because Mr. Milne reinstated this loan by making
Wait, so then the
payments in
2011
full.
action was discontinued?
Yes.
And, okay, because it appeared from your adversary that we didn't know what happened after, once the complaint was filed.
Again, I'm sorry, none of this is before the record before your honors. So I had to do some digging following the full submission of this. But yes, it was discontinued because Mr. Milne had reinstated the loan in full and continued making payments on that loan until August of 2013.
Okay, thank you. Gellis versus Salvage. You may proceed.
Good afternoon, Your Honors. May it please the Court. My name is Brian Morano for the appellant. The appellant is seeking a reversal of the lower court's order granting summary judgment to the plaintiff here on her adverse possession claim. This is an adverse possession claim under the old statute as it accrued in 2007 prior to the change of the laws. So in addition to those 5 elements of adverse possession, the claim here is not based on a writing, so the plaintiff also had to demonstrate that the property that is sought to be adversely possessed is substantially enclosed or usually cultivated or improved. Now, with respect to the enclosure, the record does not indicate any type of structure or landmark or anything that surrounds the garage and driveway at issue here. The plaintiff instead...
We have evidence from the Gellis family that they made substantial improvements to this garage, including fixing the roof and pouring a new floor, etc.
That was all in respect to one facelift made in 2006. There's no usual...
Putting a new roof and a new floor is not just a facelift. But you continue.
But to your point, Your Honor, that's a single...
Does it need to be more than a single?
It's usual improvements or cultivation. So one instance of a renovation project in 2006 does not rise to the level...
And what case law says that? What case law says that?
There's no case directly on that point.
Okay,
But
so that's just your statement of what usual means.
Correct, and it's also the fact that the plaintiff also then left the garage thereafter to deteriorate. They left it alone. They admit that it was in a state of deterioration. The plaintiff's husband removed the garage doors thereafter, allowing anyone or anything to enter it. There was no...
Weren't they parking their own cars
They
in there?
didn't say that.
Weren't they parking their own cars in there?
Intermittently, yes. That's with respect to a different element of the cause of action. They claim...
I'm more concerned with what your client says they exercised over this garage.
Sure.
So you keep on focusing on how much they did. What did your client do?
Sure, Maria Savage...
Over 20 years.
Yes, she occasionally parked her own car or allowed her car.
Not there.
Isn't there information in the record that she requested permission to park in the garage and she was told she could not?
Right, after the renovation in 2006 was on that record.
I see nothing in the record that your client ever parked her car in this garage. Point me to where in the record it says that.
I'm not disputing that, Your Honor.
Okay, so then your last statement about her parking is not
she
an accurate statement about her parking in this garage, which is the only thing that is relevant.
She allowed contractors of her own to park in the garage and
During the demolition, that doesn't count.
Is that what you're talking about?
Yes.
Yeah, that doesn't count.
We're talking about before that, in this, the period where we're measuring if it was adversely, possessed. And I really do want to focus on how we started out with the walls, the concrete. Why does that not equate to now being substantially enclosed and improved
Because
under the old laws?
They are claiming adverse possession of the stone garage. The property that is sought to be adversely possessed must be surrounded by something. The structure itself can't act as its own enclosure.
There can be improvements made that would also go towards that particular.
You're saying there has to, wait, I want to make sure I understand your argument. You're saying for there to be adverse possession, there had to be some structure surrounding the structure.
Correct, Your Honor, and
That's wrong. Tell me where it says that.
Sure, there's actually the plaintiff lists several cases that point out exactly what.
That say that a structure has to be surrounded by a structure for there to be adverse possession?
Correct.
Because remember that your statement was that what they're seeking to adversely possess is the structure itself.
Correct.
The garage.
Yes.
So that garage has to be enclosed?
Yes.
Well, they necessarily have to be claiming the land on which the stone garage is situated, right?
They're claiming the stone garage and the driveway. That is what is before the court right now. The stone garage and the driveway.
But it's really the area, the land where it sits, right? Because the issue is that it's on the property line of both parties.
Right.
And so if they're claiming that they adversely possess that area, it's to get a claim over the land.
Correct. So the land, if Your Honors look at the record, there's a survey, I believe, pages 90 and 91. The adverse possession claim is also attempting to get the footprint of what used to be a roof of the garage. Right now there's no roof on the garage. It had fallen into ruin. They're claiming.
And demolished by your client.
Partially, and also left it to be deteriorated.
Let's not forget that part.
But Your Honors, if you look at the survey itself, the meets and bounds that they are seeking adverse possession of extend beyond the walls of what was the garage. And that line was never enclosed by anything.
You're talking about the eaves of the garage?
Yes.
Okay, the eaves of a structure are considered to be over the land.
I understand that, but
So that is part of what is adversely possessed.
understood, and just
Got it.
I reiterate that portion was never enclosed.
Okay, I don't think it has to be, but I got it. All right.
I got excited.
May it please the court, Thomas P. Higgins for plaintiff respondent Amy Gellis. There is no case that we are aware of or that was cited that says that a substantial building like a garage has to itself be enclosed by an enclosure. That doesn't make any sense. All of the cases that we have here, to me, go to the point that.
So if I understand his last statement, what he means is that the eaves of the garage, which extend beyond the wall of the garage, that little 6 inches, 8 inches, whatever it is, isn't included within the meets and bounds of the building of the garage itself.
I think that's what counsel is saying.
Yeah.
And the fact is that we do seek the portion of the overhang, and we seek where the driveway was, which are all improvements under the case law where tennis courts and fences and hedges and those areas are clearly something that is a substantial enclosure. And
How far beyond the eave of the garage does this driveway extend? How much land is your client seeking to usurp from the defendants here that goes beyond the eave of the garage.
Nothing beyond the eave of the garage, nothing beyond the
So
overhang.
you're saying the driveway line ends at the eve of the garage?
What you had, Your Honor, and
Please answer my question if you
I
can.
I'm going to answer it by giving you a reference to exhibit to the amended complaint, which has a drawing. And
Okay.
the drawing shows that the garage is, well, the driveway is not within the eve of the garage. The driveway leads up to the garage from Huxley Avenue. And it leads up to the garage, probably, I'm going to say, about 10 feet.
No, but I'm talking
Counsel,
about
what
the
record-
width of it. I'm sorry, I just want to clear this up. So here's the garage building.
Yes.
The driveway goes down this way. Is there driveway that extends to the left of the garage or the right of the garage? I'm not sure which side your property is on.
I would say no, that it would be coextensive with the eve.
With the E, okay.
Yes.
All right, so go ahead.
So you have all those areas, and you have the evidence that they put in below consisted of one affidavit of Pierre Sauvage, who admitted that he had no knowledge. He had no knowledge. He made allegations about there having been consent to use this by the prior owner of the Munsons for 18 years.
Counsel, just in terms of the usually cultivated or improved, which would go to the claim of right, your adversary seems to imply that the one concrete pouring, the one fixing up of the garage that took place years ago is not enough for that particular additional element. Do you want to address that?
And I will, Your Honor, because that mischaracterizes what's in the record. And there are two extensive affidavits from both Amy Gellis and Ron Gellis, where they talk about how when they bought in 1979, I believe, that they rented it out to another party and took rent for that. They used it for parking. They used it for storage. They kept it in repair, including post-2006, 2005, 2006, when they did major renovation work by pouring a brand-new concrete floor. And in that, there's an incident here that is not addressed, but I think it's very important. At that point, after fixing up the garage, Ron Gellis testified that both Pierre Sauvage and Maria Sauvage said, hey, the garage is pretty nice now. Do you mind if we use it? And he said, I'm sorry, you can't. Mr. Sauvage, who was with us, Mrs. Sauvage has passed away, but Mr. Sauvage, in his affidavit and his deposition testimony, doesn't even address that. He doesn't say it didn't happen. He doesn't, just very conclusory, no comment on it. And I think that right there sums up all the elements of adverse possession. Someone who is using for their own purpose.
Counsel, you mentioned a survey you had in front of you. What record number is that?
Exhibit A to the amended complaint.
That's it. That's all I need.
And one other point I'd like to address, literally the only circumstance in the record when Maria Sauvage or her family attempted to exercise control over the stone garage was on April 28th, 2015, when a bunch of contractors came up and knocked half of it down. Mr. and Mrs. Gellis left work, showed up there, called the police, said, get these people off our garage. Police said this is a civil matter, and they filed this lawsuit the very next day. So for them to rely on that as some sort of factual record that undercuts the notion of exclusive control just doesn't make sense.
Thank you.
Any other questions, I'm happy to address them.
Thank you so much.
Thank you, Your Honor.
Okay, you have 1 minute.
Thank you, Your Honors. Just briefly with respect to the motion itself, the plaintiffs have the burden to make out their prima facie case of adverse possession through clear and convincing evidence. Obviously, our position is that the clear and convincing evidence standard was not met with respect to the continuous use portion of the adverse possession claim. They submit a rental agreement with a trucking company that expired less than 2 years after the plaintiffs.
Their statements that they used it is enough.
Respectfully, Your Honor, they haven't said a specific date that it was used.
That is enough.
But it's for a clear and convincing evidence standard, when they said that they have used it in the way that they did, which is directly contradicted by the defendant's account of how it was used, both when they owned it and when the prior owners
What's the
owned it.
contradiction in the record that you speak of?
The permissive use and the shared use. Now,
I saw nothing in the record of any permissive use. I saw nothing in the record of any shared use by your clients and the Gellis family. But we have the record. Thank you.
Thank you, Your Honors.
People versus Affleck.
afternoon. My name's Lorraine Medello, and I represent.
Can you bring the microphone closer
Dwayne
to
Affleck.
you?
Yeah, get closer to that mic so
Oh.
we can hear you.
Sorry. Mr. Affleck was denied his right to a public trial when the court excluded his pastor and supporter for
Was the pastor actually excluded?
Yes, he was excluded for a portion of the trial. Yes.
After being admonished several times to stop using his phone, and he ignored the officer's direction.
There was apparently, according to the record, there was interaction between the pastor and the court officer.
And didn't the judge permit him to be able to return to the courtroom, but with the proviso that he follow the court rules?
The next day, the court excluded the pastor for the afternoon session. What happened is the defense counsel alerted the court that the pastor had been excluded. The court said, I don't want to deal with it now, I will deal with it at the end of the day. The court made no finding.
Does the court have some interest in maintaining decorum inside the courtroom so that the trial can progress?
Yes, of course.
Especially when it is a stated rule in the courtroom that you are not to use any electronic devices that could be used as a recording, right?
There was no indication that anyone was recording anything. There is later, in the later discussion, it says that the pastor was looking at his phone, but the court's first statement when it's directed to him says, counsel, I'll deal with it when we finish the case. We're going to continue the trial. Defense counsel objects that it's not an open trial, and the court says, you made your point. He goes, I'll deal with it at the end of the day. I note for the record, I have seen no improper actions by anyone in this courtroom. So the court's own statement is that the pastor did not disrupt the proceeding, does not disrupt the decorum.
I took that to mean he was unaware, and he needed to speak with his officers to find out what they saw, and didn't want to interrupt the trial at that moment, and chose to deal with it after the segment that was being dealt with at the moment.
But it doesn't work that way, because Mr. Affleck's entitled to...
Please enlighten me how it works.
Mr. Affleck is entitled to a public trial. And if the court is going to...
Is your client entitled to a witness, to a guest in the courtroom who speaks to him openly while the jury is in the room?
There is no indication.
Because that was the allegation, that he made some, keep your chin up.
That was as he was being escorted out.
Counsel, a couple of days prior to that, wasn't he yelling out things in the courtroom?
There's an indication, it says at a prior allocution, which is not during the trial. There's no allocution during the trial. So that must have been some other proceeding that they are now bringing up. But the problem is, if the court is going to exclude my client's supporter and deny him his right to a public trial, he has to conduct the 4-part Waller test. The court did not do that before excluding the pastor. The court says, now I'm excluding him, now we'll continue.
Did the court say that? Now I'm excluding him?
No.
Well, he said he can't come back in, and we're continuing
And
with the
we will
trial.
deal with this at the end of the day.
At the end of the day, but he was excluded. Defense counsel asked, can he come back in? And he was told, no, he can't come back in. So the trial proceeds that afternoon. He's been excluded.
I thought
And by the morning, he's back in.
At the time that this happened, the trial was already over. Isn't that what I read?
No, the trial was not over. There were summations, and there was...
It was in the middle of summations? So it wasn't the actual trial, it was summations, which is evidentiary in nature, right?
Part of the trial. It's part of the trial that my client has the right to an open trial. And the
Does he have a right to a spectator that's disruptive?
But there's
in the
no
courtroom?
showing. Before he's been excluded, there's no showing that he was disruptive.
The court did state on the record, though, that the pastor had consistently violated the rules of the court, not only today, but in prior days. and that he could return if he followed the rules. That, I mean, the court did state that. Why is the court, what else is the court required to do?
Because the court stated that.
According to the record,
after
it wasn't until after summations and after a lunch break that defense counsel moved for a mistrial, stating that the pastor had taken out his cell phone and was asked to put it away, and then told the defendant to keep your chin up. And pastor was told not to return after the lunch break.
Yes.
So after summations and a lunch break. So what would have happened after summations would have been
Charge
just a
to
charge.
the jury, and I believe it was still the prosecutor's summation. I believe it was only the defense summation in the morning.
It said after summations, it doesn't
That goes
tell
to
me.
the other issue of that the court changed its ruling between the defense and the prosecution summation, which I believe was after the lunch break. But when the court speaks to a court officer after the defense says he's been excluded, it's not an open tournament. The court speaks to the court officer. The court makes none of those findings on the record until after the exclusion. That is the primary problem here. There's twofold denial of my client's right to a public trial, and the most important one is that the court, whatever findings in Waller test and that the court
Let me
was
just
going
make
to
sure I
exclude.
understand because I see your lights on, and you can answer this on rebuttal, maybe you could think about it. Your position is that when someone is disruptive in the courtroom, regardless of how that disruption affects the trial, the court has to, at that particular moment, make these conclusions, or is it not sufficient enough that the conclusions are made?
First of all, he wasn't disruptive. The court says, I didn't notice any improper actions. So it wasn't like the pastor stood up and started screaming in the middle of the trial.
He pulled out the phone after the officer told him not to pull out the phone.
And the court could have conducted.
So what my colleague is asking, and I'm interested in knowing the answer to this question, are you suggesting that the rule we should employ is that trial courts must stop everything? Absolutely everything. It doesn't matter at what stage the trial is, we must stop all action. The moment there is an issue involving whether someone should be excluded or not excluded in the court has no room to say, okay, we're gonna finish right here and then we're gonna address this issue.
It was stopped.
I'm asking you whether the court has the ability to decide when it will entertain the application concerning the open courtroom.
No.
No,
court
they have to
has
stop everything.
The court has to entertain that application.
They have to stop everything on the spot, is what you're saying.
What I'm saying is the court has to entertain that application.
Counsel, I'm asking you a very direct question.
I'm answering it.
And no, you're not. I'm asking you, does the court have to stop everything at the moment that defense counsel says there's an open trial court issue, so you have to stop everything so we can entertain this issue? That's the rule you think we should employ?
Generally, before the court would exclude either part of the public or whatever, say at a Hinton hearing.
Okay,
the court
I
would
got
have
it.
that
You're
hearing
saying
before
the
it
court
makes the
should
ruling.
stop everything
Before
before it continues.
before
I got it.
it
You'll have
makes-
time on rebuttal. Your red light has been on for quite some time. Counsel, you're up next.
May it please the court, Alexander Michaels on behalf of the people.
Is that the law? That the court has to stop everything the moment that this issue comes up?
No, Your Honor. And what happened here actually makes perfect sense in that the court, of course, had observed misconduct in question, and it had received the report from the court sergeant about the misconduct in question, or some of the misconduct in question, when it decided, okay, yes, we're going to have that exclusion for the afternoon. And then the court said that it would return to the issue at the end of the day. And when it returned to the issue at the end of the day, that's when the court made the detailed record. So this is not like a situation with an evidentiary ruling in which the court doesn't spell out all of its reasoning when the ruling is made.
Am I incorrect that after, while deliberations was going on, because this application happened after summations, so during deliberations, am I correct that the court stated, quote, the pastor had consistently violated rules of this court, not only today, but in prior days? Did the judge say that?
Yes, absolutely.
Okay, I thought I was mistaken.
No, Your Honor. That's absolutely what the judge said, and that level of specificity, the level of detail that the judge walked through at that stage demonstrates that there's no
So
way.
let's turn to the summation issue.
Sorry, Your Honor.
Right. How is it proper for the judge to revisit its ruling on charges after summation?
That is an error. The Court of Appeals has been very explicit about this. It is an error when the court revisits its ruling at that stage, but a crucial showing must be made in order for it to warrant reversal, and that is a showing of prejudice. And that showing absolutely cannot be made here. And the review of the defense summation makes that.
Well, how is it not prejudicial here when defense counsel didn't have an opportunity to really address the issues that were then going to be charged to the jury?
Well, defense counsel did have an opportunity because he was given an opportunity to reopen his summation.
Oh, but that's not an opportunity. That's a death sentence for a defense attorney.
Well,
let me go back and say, oh, by the way, I forgot these arguments. That never works, counsel. That is not that's not a substitution for a prompt and proper ruling by the court.
Well, the Court of Appeals has also made clear that in order to assess any prejudice in this setting, what the court needs to do is look at whether the defense detrimentally relied on the initial ruling that was subsequently changed.
And in this case, how did the defense not detrimentally rely on it?
The defense didn't rely on it in any way because the defense didn't actually get into the specific charge of assault 2. That's the assault 2 that would be simple assault coupled with a particular predicate felony. The defense did not bother getting into that whatsoever, and that made a lot of sense because the defense angle in summation was entirely that the defendant had committed, yes, a simple assault and had done nothing more. And that argument applied with equal force whether the predicate felony was the kidnapping or whether it was going to be the attempted rape. And so the defense lawyer did not mention the second-degree assault at any moment in his summation, much less get into the elements involving that second-degree assault. So at no point did he suggest that the second-degree assault, you need to acquit on that because it wasn't linked to a kidnapping. And for that reason, the jury wasn't going to be focusing on that particular issue, and the change in the court's ruling wasn't going to matter.
Although didn't the defense argue that while there was an assault, really the only injuries to the complainant were some contusions, so that if they understood that the focus would not be the kidnapping, but the rape, where the allegations of the assault are alive, right? It was in the course of the attempted rape, right, that he punches her in the face repeatedly, right? It's not getting her into the room, which would support the kidnapping charge, no?
I'm not sure I follow Your Honor's thinking to me. He's conceding that there's physical injury either way, and that was abundantly established. And then
right, but physical injury, you and I both know that physical injury on a 3 is different from physical injury on a 2.
I'm sorry, for assault 3.
Assault 2 versus assault 3, right?
Well, the only way it becomes assault 2 is because of so it's not serious physical injury. It only becomes assault 2 because of the predicate felony it's associated with. And those elements don't.
So it wouldn't matter how bad the assault was, is what you're saying. It's whether it was predicated on the kidnapping versus the rape.
Yes, and under either of those theories, the defendant was going to be guilty if the jury found him guilty of the kidnapping or the attempted rape. And that's why defense counsel didn't get into any of this, because defense counsel's argument was not guilty of the kidnapping, he's not guilty of the attempted rape, and yes, he might be guilty of a simple assault, but that's all there is to it. So that's why the defense counsel did not detrimentally rely in any way on the initial ruling. Okay. Unless the court has any further questions, people ask that the court affirm.
I don't see any. Thank you. Counsel?
If I may. Yes, the court changed its ruling at a time that did cause prejudice. It was between the summations. It was after the defense summation, but before the prosecutor's summation. So the defense counsel sits down thanking the jury, thank you, you've listened, all of that, and he sits down. And then the court's proposed remedy of you can reopen it would have the defense counsel getting up saying, I said bye, but now I'm back, really, essentially. He did rely on it. There was prejudice because he talked a lot about how when Mr. Affleck and the complainant went to the different floors, it wasn't actually a kidnapping, that she went with him, that it wasn't enough. And that's what he had originally been told, that the assault 2 was going to be in furtherance of the kidnapping. He doesn't have to say in summation, I'm arguing assault 2 versus assault 3. He did concede physical injury. He did not concede serious physical injury, which would have been freestanding assault 2. So he did rely on it. The court's remedy was not sufficient, and he was prejudiced, and the court should reverse on that basis. In addition to the basis of the exclusion.
You're out of time. I'm gonna give you 30 more seconds. Go ahead, finish whatever else you want to say.
No, that's it.
You're good? Okay, all right. Thank you. HSBC Bank versus Nomura, Nomura Home Equity versus Nomura Credit. You may proceed.
Your Honor, may it please the court, Stan Chelney for Auckland Loan Servicing, the appellant on the first appeal, and the respondent on the second appeal. With respect to the first appeal, the trial court erred because it denied summary judgment to Auckland based on accusations by a regulator and unproven allegations by class action plaintiffs relating to completely different loans that had nothing to do with the loans that Auckland was accused in our case of improperly servicing. And in so doing, the trial court relied on both inadmissible hearsay and also evidence that is not probative of how Auckland serviced the actual loans at issue here.
Or could it be that the documents that were submitted raised an issue of fact?
They didn't, Your Honor, and this court just dealt with this issue in the Brevet Direct Lending case. And in that case, it also dealt with a contract that had a contractual limitation of liability like our pooling and servicing agreement contract here has in 7.04, which limits Auckland's liability to gross negligence or willful misfeasance. And in the Brevet
And
Direct
there's
Lending-
certainly more than enough allegations here for that.
Well, that's just the thing.
More than enough.
Allegations by class plaintiffs, by regulators about different loans years after these loans were serviced. And what Nomura needed to have done to get to a jury in this case, under the Brevet Direct Lending case, is to show conduct by Auckland that evidences gross negligence here. And it did not do that. It could not have done that. And the trial court does not rely on any evidence as to these loans of gross negligence. She relies exclusively on evidence about different loans from a different time period, allegedly. And we know that there is no evidence in the record about these loans because Nomura's expert witness testified, he admitted, he didn't actually examine Auckland's conduct when servicing these loans, nor does he even opine in his expert reports that Auckland committed gross negligence.
What we do have is triply inflated fees based on servicers that your client chose that have direct relationships with your clients' businesses and interests. So there's plenty here.
Well, Your Honor, that's not in the record as to these loans. And the expert witness here, Mr. Lendez, on those fees, he admitted he did not look at what fees were charged on these loans. His report doesn't catalog that. And the one thing that on triply inflated fees, the allegation as to other loans, that he does not even state a standard by which he claims the fees are inflated. This court has ruled in the Gerber case as well as in the Griffith case that an expert who makes an opinion needs to base that opinion in some standard in the industry.
And so when the expert, for example, indicated that there was a failure to make prudent servicing decisions, that's too conclusory.
Well,
not really based on anything?
Your Honor, when he opines that Auckland did not act prudently, that is not gross negligence. That cannot be gross negligence. Gross negligence evinces a reckless disregard or smacks of intentional wrongdoing. he doesn't even reach that opinion. There is nothing in this record that says that Ocwen acted with gross negligence, nor could he, because he admits that he didn't actually examine what Ocwen did when it serviced these actual loans. So what he does is he says, because in 2015 and 2014, by which point over 90% of these loans had already not been liquidated, they weren't even being serviced anymore, because different loans, some regulator alleged Ocwen did something as to different loans years later. I'm just going to infer that they must have been doing the same thing as to the loans at issue in this case, where this pooling and servicing agreement requires an individualized examination. And the Court of Appeals in the DLJ case made very clear that Nomura has to prove loan level gross negligence.
This was Ocwen's motion for
Correct.
summary
Ocwen is
judgment?
making the
Would
motion.
Ocwen not have a burden to show that, in fact, the loans were different?
It's your burden.
It's your burden.
Not Nomura's.
Nomura is the plaintiff in the third.
You made the motion for summary judgment, so you have the burden. How have you shown? How has your client shown that they were in conformity with their R&Ws?
Well, Nomura is.
No. You made the motion. So you can keep on trying to get us distracted and pointing at Nomura. I'm looking at you. What did you prove?
Your Honor,
You're moving for summary judgment.
not a distraction because the Court of Appeals has made clear that there needs to be loan level evidence. There is no evidence.
Right, but on summary judgment,
Right, that's for the trial.
the movement has to make a prima facie showing of entitlement to judgment in a matter of law, and that has to be an affirmative showing. We can't point to gaps in the non-moving party's proof. So what evidence did you submit that would discharge your prima facie showing?
Well, the evidence that we cite to in our brief is that by the time that all of these allegations, these hearsay inadmissible allegations were made, over 90% of these loans weren't even being.
Did you do that on a loan-by-loan basis? Did you show that on a loan-by-loan basis, or was that just summarily because that's years later?
No, apparently that obligation is only for Nomura, right?
Of course.
You make the motion, but they have to prove loan by loan. You have to prove
it.
Your Honor, we made the motion that there's a lack of evidence.
Did you establish that none of the loans in the trust were subjected to FPI that involved kickbacks? Did you establish that?
There is zero evidence.
Did you establish that?
It was not our burden to do so.
Yes,
You
it
move
is.
for summary judgment. You're the movement.
Your Honor,
Yes, it is. But you'll have time on rebuttal.
Good afternoon, Your Honor. Joel Chernoff, on behalf of the respondent, Nomura Credit and Capital. May it please the
Why
court.
didn't Nomura show on a case-by-case basis, a loan-by-loan basis?
Your Honor, we did show loan by loan. That's just a falsehood. Where the evidence was provided to us to do loan by loan, we did. We showed, for example, that with respect to, let's take the auction website Hubzu that you might have read about. Mr. Lendes, our servicing expert, found that with the Hubzu charges, the commissions that passed through were 10 and 11%.
But he said that it wasn't reasonably prudent. Is that gross negligence? Malfeasance as what the
Mr.
contract
Lendes
calls
didn't
for?
use the magic word gross negligence. We concede that, but this court's well beyond magic words. What they did show, what he does find, is that they failed to comply with the PSA, which is the pooling and servicing agreement. They failed to comply with customary industry standards, which are here called accepted servicing practices, and that's detailed in my brief, but I can read you chapter and verse where he goes through and he finds they were supposed to do an analysis for repair and renovation. They didn't do it. That doesn't comply. They were supposed to charge off loans where your loss was going to be greater than the loan value, i.e., you have a loan for $10,000. It's going to, if you try to foreclose this, you're going to have a loss of $12,000. You should walk away. You should charge off. Mr. Lendes found that for 30% of the loans, they didn't do that.
Well, counsel, what about the claim in the record that there were certain loans that your client was advised of but decided not to repurchase, so that you wouldn't have repurchased these loans in any event?
That's, Your Honor, the court below dismissed that claim, and we are not appealing that. That was our claim for failure to provide notice, and we are not cross-appealing.
Okay.
Our This appeal is solely with respect to, is there sufficient evidence of Aquin servicing misconduct to go to trial? And we submit there is ample evidence. The contention that Mr. Lendis didn't look at the loans, that's wrong. He did. Now, did he do granular research into certain of the claims? No, and why didn't he do it? He didn't do it because Aquin said, when we decide, let's go back to that example I gave you, should I foreclose? They use something called the net present value method, or an NPV calculation. We asked them, give it to us, give us your method. They said no. We said, tell us the factors that go into that calculation. They refused to provide them.
Did you guys submit any claims, the claims which summary judgment was based on? Did you plead those claims?
I'm sorry, Your Honor.
The claims for which summary judgment was based on here, did your client plead those claims?
Did our client view them?
Plead them.
Plead. Yes, I'm sorry. I didn't. We did, Your Honor. We believe the complaint is sufficiently detailed. For example, he says they had no notice about the regulatory actions, which was with respect to their related transactions. Well, if you look at the complaint, we complain about related transactions. We specifically reference in paragraph 54 a letter from the New York Department of Financial Services of April 21, 2014.
Also, but he argues that this is inadmissible hearsay that you relied on.
does.
What is your argument to his argument?
Well, he didn't raise hearsay below, Your Honor. So one, the court didn't get to consider if it was hearsay, and two, they didn't get to consider if any of the exceptions to the hearsay rule apply. For example, two of the documents we're talking about are consent orders. Aquin negotiated and signed those.
If I understood your friend correctly, he said that the consent orders didn't relate to the toxic assets that were being scrutinized in this litigation.
He did, Your Honor. But what the consent order shows is that, for example, one of the consent orders talks about Hubsuit, that auction website, and charging different amounts. 4.5% if it's an Aquin loan, 1.5% if it's not an Aquin loan. Well, what do we have in our case? We have an auction website, and we find, Mr. Lendis found they charged 4.5%. So the same conduct about which the regulators complained is at issue in our suit, just like it was in the consent order. When we asked their experts and their representatives, can you tell us that our loans were not encompassed within those investigations? They couldn't. When we asked them directly, will you tell us that? They refused to. Your Honor, we submit that it was entirely appropriate to return to the hearsay question for the court to look at those, for our expert to look at those regulatory actions and consent orders, because there's something called the professional reliability exception. And again, the trial court didn't get to hear the evidence on this because it wasn't raised. But we believe anyone reviewing servicing and trying to figure out, is it good, is it bad, will want to know, what do the regulators say before I start my job? Why wouldn't I want as much knowledge as I can?
Thank you.
Thank
We have
you.
4 minutes on the other side. Then you. They split their time.
May it please the court. My name is Amiana Stovall for Nomura, the appellant. The decision at issue on this appeal, concerns the impact of Nomura's settlement of the first party action with the trustee and the standard of proof applicable to Nomura's trial of the third party action for servicing misconduct with Aquin. And we submit, Your Honor, that in circumstances where, like here, where Aquin participated in the underlying litigation, had notice of the settlement, and could have intervened in the Article 7.
Did they have a say in the settlement, though?
They attended 5 mediation sessions. In fact,
Decision.
How
when I
can they
say
control the
say-
defense?
When I say say, I mean any decision-making power in the settlement.
they could have participated at any time. We sat in a room for 5 days negotiating settlements, and then thereafter, because it is a trust situation, the trustee had to bring an Article 77 proceeding in order to confirm or implement the trust. And so during the course of that process, Aquin, who is a party to the PSA, had access to the trust's website where that settlement was posted, and then it could have intervened in the Article 77 proceeding. So between the time the settlement was negotiated and posted, and by the time the first party action was ultimately disposed of, because the Article 77 proceeding ultimately the court decided to implement the settlement, Ocwen had 8 months.
What role did they play in the defense?
Ocwen was a third-party defendant. What happens is that when Nomura puts the loans into the RMBS trust, Ocwen then services those loans post-securitization. And so then Nomura's position was that to the extent it had to repurchase any of the loans in connection with liability of reps and warranty breaches that it faced in the first-party action, those damages were exacerbated by virtue of Ocwen's misconduct in connection with servicing those loans post-securitization. And that's what makes up the purchase price going forward on these loans. And so it was an exacerbation of those damages. That is what caused Nomura to bring Ocwen in as the third party in the first instance. And so because Ocwen was involved in those settlement proceedings, or could have intervened in those settlement proceedings, and also because Nomura is not asking for the full settlement amount in reimbursement for the $58 million settlement that it ultimately paid to the trustee. It's actually only asking Ocwen for about 11 to 16 million of that settlement. Nomura submits that it's appropriate to apply contractual indemnification concepts such that on the third-party trial, Nomura need only prove that the settlement in the first-party action was reasonable and made in good faith. Thus, similar to concepts developed in the indemnification context, as in Trilinks, Deutsche Bank versus Trilinks, which is one of the court's prominent decisions in this space. It precludes the need to engage in a trial of the first-party liability on a loan-by-loan basis with respect to the remaining approximately 300 loans, and thereby avoid a trial that the settlement in the first-party action was intended to avoid. Right. That is why Nomura entered into that settlement. And so, sort of consistent with cases like Deutsche Bank and its progeny, this court has concluded that where a settling part, or the indemnity, has notice of the underlying settlement, and it's afforded the opportunity to protect its interests in that proceeding, and it could have intervened in the proceeding, it's appropriate that there's no need for the settling defendant to demonstrate its actual liability. It's sufficient only to demonstrate that it had potential liability, that the settlement was reasonable, and that it was made in good faith.
Thank you. You have 2 minutes.
So addressing the last presentation, there is no law supporting the unprecedented relief that was asked of this trial court. The cases on which Nomura relied to the trial court and relies now are all in the context of contractual indemnification, which Nomura admits it is not seeking here from Ocwen. Ocwen did not have any of the obligations or the rights of an indemnitor, and Nomura did not have the rights to have Ocwen pay as an indemnity. So all of the cases on which they rely are completely inapposite. And the reason is described in those very cases that they cite. Under the Fuhrer case, under the Trilinks case, the only reason notice is relevant is because the indemnitor has the legal right to step in and take over the defense of the action. And if it does so, then it will be bound by res judicata principles.
And Ocwen had no control over the defense.
No control whatsoever.
Or the settlement with the plaintiff.
And the notion that Ocwen participated in the mediation is completely false. We were siloed off from the first party mediation. That was entirely a Nomura versus the trustee discussion. There was no participation. Ocwen wasn't informed about what happened there. That's one of the problems. The other problem is this is an instance where Nomura has a element of its case. It's a contingent case. It admits that Ocwen is not liable unless it is first liable to the trust for a breach of a repurchase obligation on a specific loan. And only as to those loans can they proceed against Aquin. And they want to just skip past the entire first step and go straight to a trial on Aquin on every single loan, whether or not a first-party trial would have found them liable. And it's just, there's no law that supports that. It's completely improper. On the other point, I just want to make one illustrative point to explain to the panel why their expert did not develop gross negligence evidence on a loan level. He, for example, opines that certain loans in this case had 100% loss severity, and he automatically just blames Aquin for that eventuation. And he was asked at his deposition, does the pooling and service agreement require loss severity to be under 100%? Answer, no. Well, can loss severity exceed 100% through no fault of the servicer? Answer, it can. Question, what did you do to figure out whether on these loans the loss severity exceeded 100% because of something Aquin did, or because, for instance, Nomura securitized defective loans, or there was a global housing crisis? And he did nothing. And it's the same with all of the work he did. It's entirely hindsight-based. Something ended badly with a loan, and he just automatically assumes in his report that Aquin must have done something, all while conceding he did no actual looking to see. And the pooling and servicing agreement in this case, it's a contract, it's individualized. It's undisputed that Aquin had the obligation to individually service loans. And they need to prove evidence in this. There is no evidence in this record of how Aquin serviced these loans, and there can be no evidence of gross negligence in this record for that reason.
Thank you. Interiano versus Silverstein Galaxy. You may proceed.
Good afternoon. My name is Paul Golden. I represent the appellant Silverstein and American Broadcasting. The worker was on a scaffold.
We know the facts.
I understand.
So I'm trying to understand on this fact pattern how she's the sole proximate cause when she asked the person in charge on her crew, tie the scaffold to the building. It's swaying from the wind.
Well,
I don't understand at all why we're here.
The primary argument I've got concerns that 240 subsection 1 doesn't apply.
240 subsection 1 applies. She's on a scaffold that's swaying in the wind 4 stories up.
That's right.
Yeah.
It's swaying horizontally.
It doesn't matter.
Well,
she is on a piece of equipment that is affected by gravity.
Well,
we're lucky she was tied.
All equipment is affected by gravity. We're affected by gravity all over the place. But that's not the rule. It's not just simply.
Counsel, I suggest to you that is not your strong argument that this is not a gravity-related event.
This would be the first known case in which I understand.
No, it wouldn't.
I understand.
But I'm sure I understand why you want to say that, but it's not. We've read thousands of these cases, have gone through thousands of these cases, and this is not the first time that a scaffold sways.
This is the first case I've ever seen, certainly, where a scaffold that sways back and forth, and someone falls on the scaffold without falling down. They're totally connected. They're not.
There is no case that says you have to fold off the scaffold for it to be a 240 case.
No, what the cases indicate is the safety devices have to concern a gravity-related.
So the safety device here was that this scaffold should have been tied to the building, was it?
No, it wasn't.
Okay, so that is the safety device that would have prevented this woman from falling on the scaffold. So explain to me why the failure to tie the scaffold to the building doesn't constitute a 240 sub 1 violation.
It doesn't matter where it is, whether it was 6 inches from the ground, whether it was 10 feet up, 100 feet, or 1,000 feet up. we're talking about something that shakes horizontally.
So is it your position that if something shakes horizontally, that can't be a 240? I don't really understand that.
Certainly, if she's moving back and forth horizontally and falls on the same level, that's a very different issue from what 241 was.
What case says that?
Well, what the cases indicate is that the same.
No, what case says that if you're on a scaffold that sways horizontally and just fall on the scaffold, that doesn't inject a 240 sub 1 analysis? What case says that?
One case is Preculi, which held that a fall on an elevated platform may not necessarily be a risk related to elevation.
When was that case?
97, if I'm not mistaken. I don't believe
97.
Yes, but there's nothing indicating
But
that
this
that's been
isn't
overruled.
this just isn't a fall on a platform. Something happened before she fell on the platform. This is not those cases where someone trips on a wire or something like that and then falls. There's a scaffold that is suspended in the air that is moving because of the wind and also because of a drill that's being operated at the same time. And there's an opportunity to have this scaffold tied off. That opportunity is not taken by not her, but by the coworker who knows how to do it. So I don't understand how you're equating these cases where someone falls on a horizontal platform, and that's not what we have here. This is not something that she just that she just fell. This is something that was moving.
Sure, it was shaking from horizontally.
What does it matter what direction the shaking occurred from?
The issue, I appreciate the question. The issue is that the case law indicates if someone is falling because they're not tied on to something and they would fall down, or if they're trying to protect someone else because they're holding something.
So if she fell out of the scaffold.
Say that again?
If she fell out of the scaffold, then it would
Yes,
fall in.
but we had the safety device there because she was connected to the harness.
Except she should, counsel, you are ignoring the fact that the scaffold should not have moved at all had it been properly tied with the safety device that was available and that her coworker, for no good reason, chose not to use. But you'll have time on rebuttal.
All right, thank you so much.
Good afternoon, and may it please the court. I'm Denise Rubin with Subin Associates, appearing today for the plaintiff respondent, Nelly Gonzalez Interiano. We have a problem of facts here because it wasn't moving horizontally when she fell. Her testimony was that she was bent down, picking up debris. Her partner was drilling into the wall, and that intermittently, when he had been drilling, the force of the drill and the force of him pushing on the drill would move the scaffold away from the wall, up to 3 feet at times. And that in this particular instance, she stood up, she was on her feet and standing up, and she says at approximately 3:30, she fell on the scaffold. Just prior, she was standing on the left side of the scaffold facing the wall, and her coworker was drilling into the wall on the right side, that it suddenly precipitously moved more forcefully than it had up until that point, and that she fell.
So it moved away from the wall versus swaying back and forth.
That's what she testified, that it was because he was drilling and pushing on the drill, and that for some reason, this particular time when it moved, it was much more forceful than the times before. Also, she did not have time to grab something to brace herself, which most of the time she had been able to do prior to that moment. She fell, hitting her neck on one horizontal pipe and her lower back on another.
And her testimony is leading up to this accident, she had been telling all of her supervisors that she would like to have this scaffold tied to the wall, correct?
She had told her coworker repeatedly, and he rather demeaningly laughed her off, saying, "Oh, it's cool, you're fine, I'm not even tied in, and you have a harness, don't worry about it." She told her friend Susanna, who cautioned her, "Don't fight with him on the scaffold, he's senior to you. Tell David." David, all of their supervisor, the first day had left by the time she was back down on the ground. But
On the day of the accident, before she went up, she told him about her concern, that she was afraid, and he did nothing
Correct.
to ensure that her coworker would utilize the safety device that was available to tie off that scaffold while he worked.
here's the thing, he did something. He told everyone, be sure you tie off the scaffolds while you're working. He did tell them. And he actually says that in his affidavit on the motion, which he did to show that she didn't tie it off and it's her fault, but in fact it militates in favor of her position, which is to say, everybody on the site knew it was supposed to be secured, her coworker knew it was supposed to
And she didn't know how to tie off. It was the coworker.
She
who-
didn't know how,
Right?
no. And this was her first day, and she did not anticipate working on a scaffold at all.
Didn't she tell them, I've never worked on a scaffold?
She did indeed on the first day, and apparently some other worker had not shown up for work, and David said, listen, don't worry, it'll be fine. It's no big deal, and let her go on up on the scaffold. Unless the court has any other question.
Thank you.
Thank you.
I'd like to address the defense about the worker and the recalcitrant worker defense. It's no dispute. There's no dispute that there is an issue, at least an issue of fact about what she was told. You
Well,
must
if
tie
she's
it up.
not provided a proper safety device in the first instance, how can she be a recalcitrant worker?
What I think we're all
Who
assuming.
testified that she was taught how to tie it off? Because she says
how to tie
she
it off.
did not know how to tie the scaffold to the building.
So this is something that a jury could decide as to.
No. You must show, in order to establish a recalcitrant worker defense, you have to show that the worker was aware and was capable of doing the conduct you say would have saved her. So I see nothing in the record that established that she had any experience on a scaffold, that she was taught how to tie off the scaffold.
So
Can you tell me where it is in the record?
I don't mean to make light of this, but if she has ever tied up anything, there's nothing indicating.
No, counsel.
Sailors.
Tying up a bow is different from tying a boat is different from tying a construction knot. There are different knots. So, counsel, I've asked you a very direct question. And if you can give me the answer, you're saved. So tell me, where in the record is there evidence that she was taught how to tie the scaffold off? And then I agree with you. So tell me where I can find that in the record.
It's not in there. However, as a matter of common sense, we can't just presume that it's impossible for just because she's a woman that she doesn't know how to.
Oh, did I say that? Did I say that? Did that just come out of your mouth?
That's the implication.
Is that what just came out of your mouth? At no point did I say because she was a woman. I said she's testified that she had never worked on a scaffold.
And she didn't say she never worked on a scaffold because she's a woman.
No, it's not because where she worked. It's
You just said.
It's an issue about.
Counsel, I really think that you should quit while you're
Yeah,
ahead of this.
I think so too.
Yeah, your red light's on too.
Whether she knows how to tie a tie.
Thank you.
Thank you so much.
And I suggest you really take inventory
I understand.
about what you just said.
I
That's it. Just take inventory, and maybe you may want to listen to the recording of this so you could see what you said.
understood, Your Honor.
Okay.
It's a tense moment when you're orally arguing. I hope you understand that.
Joselyn versus Carl. Thank you. You have 4 minutes, ma'am.
You can use the mic.
Please get behind the mic so that we can hear you.
Sorry.
Okay, not a problem.
Good afternoon, Your Honor, and everyone in the courtroom. And I thank you that you've allotted me this time to speak.
You can adjust the mic so you're comfortable.
Bring the mic up so we can hear you. Great.
May I just ask, is it all right? If it's not, it's okay for me to wear the hat because of my eyes?
Sure.
Thank you. Thank you. The light. Thank you.
So the issue before us is whether you were denied due process in entertaining the petition which was dismissed for grandparent visitation, which was brought after a prior petition had been dismissed.
Yeah.
So I will hear your argument on
Yes,
that.
and what happened was an ACS supervisor was there with me, and the moment that was dismissed, because I didn't recognize a paper, and it's not that I said it wasn't valid, I was so clear. I said, it's valid, I see my signature, but due to my eyes, I had no glasses, I didn't quite recognize the paper. And she kept asking, do you recognize the paper? And I know that the judge was very hesitant. He didn't seem to want to dismiss. But then he said, well, the woman, Miss Soslavsky, said to him, well, if she doesn't recognize it, then you must dismiss. I said, I know it's valid. I see my signature. I just didn't recognize the paper from, I guess it was 5 or 6 years ago.
That particular dismissal, though, you didn't appeal it at that, you didn't appeal that to
No, so what happened was the ACS, they just said dismissed. And when I left the courtroom, my husband was with me. He's 93 and he walks with a walker. He's very weak. And when we left the courtroom, I had to put him into a car, but the ACS supervisor told me, we have to go right downstairs and you're going to have to write another petition. Because we didn't know about, that it was dismissed forever or whatever. And there's been so many changes. And so we went down, I wrote the petition, and then that was December. 2 hours or so after it was dismissed, my son-in-law, Carl Reeves, offered my husband and me 2 hours once a month supervised at CFS. At the time, I did not respond right away. I was going to just wait and wait because we didn't have the money. We had already, we're going broke. We had already spent close to $65,000 on supervised visits. We've done nothing wrong, nothing. My husband was a lawyer, a good lawyer, an honest lawyer. And we're married 54 years. And for 50 years of that time, we've been donating our time to saving children's lives. I received awards from Steven Spielberg and other notaries. I don't know
Well,
what
all of this to say that you're a good person and a
Yes,
good grandma.
yes, yeah.
I get it.
Yeah,
but unfortunately, our court, we are limited to just the issues that are being appealed, strictly that. So we cannot assess the underlying merits of the case.
Here's the thing. So I formed this petition, and then when I went in on January 3rd, I believe it was, Judge Hassa was wonderful, Judge Hassa Kingo, and I said to him, no one else showed up, and he was quite surprised. And I said, well, is it worth going through this? And he said, yes, this is a brand new petition. It didn't have my husband's name on it, only mine. So he said, I'm giving you a second date, February 5th. And that was it. And then about 4 days later, they canceled it. Someone, I guess, talked him into canceling it. I think he was trying to be very, very fair. My little granddaughter has changed a lot. She loves me so much. We've done everything together. I was a co-parent for her, a second mother. Now she's saying things to my daughter like, I'm no good anymore. I'm poop. I'm poop. And
The red light is on, so you'll have time on rebuttal. I'm gonna give the other side an opportunity to speak, and then we'll hear you again, okay?
Good afternoon. May it please the court. Michael Belmont for the respondent,
Counsel,
Carl R.
I'm wondering if the pro se litigants here side, if she had filed a petition indicating that there had been a change in circumstance as to why she's now entitled to visitation, that would have probably been a better way to proceed, as opposed to just refiling the same petition, where you can allege now a change of circumstance. That's a better way to proceed, right?
Yes, Your Honor, that's correct.
Okay.
But she didn't do
Filed
that.
the petition on the same day that the judge had the fact finding.
Correct, Your Honor. Literally the
Found
exact.
that she has standing,
There was a prior order that the grandparents had standing, correct.
and he did a full trial on that.
We had a full 4-day trial,
And he found it wasn't in the best interest.
correct. The court found that it wasn't in the child's best interest for the grandparents to have visitation that same day.
She refiles the second petition.
Correct. The appellant filed
And
a
in
new
refiling
petition.
the second petition, she includes words that say she has not previously applied to the court for the same relief, correct?
Correct, correct. Not only that, but from the face of the petition, it's clear she was just attempting to relitigate the prior hearing.
But the procedure, once the finding has been made underneath the first petition, after the fact finding rather, would be to now allege a change in circumstance, not just refile the same petition, right? A change in circumstance?
Right.
She
in
can
a
seek a
typical-
modification petition to modify the order to allow her to have access based on new circumstances, correct?
Correct. In a typical custody visitation proceeding, that's how it works. If you're trying to modify a custody or visitation order, the case law is a little unclear how it relates to grandparent visitation. I know we cited in our brief that where grandparent visitation had been denied previously, now granted it was the issue of standing that had been denied. The Supreme Court, which was Justice Sachs at the time, found that res judicata applies and the case had to end.
But that's not the situation here because she has standing. The court found she has standing, correct?
The court previously found she had standing based upon where conditions exist which equity would see fit to intervene. It's unclear, and I haven't seen a case where a court then thereafter finds that it's not in the child's best interest for there to be visitation. I mean, I think there's still an issue where in the future could standing be.
Why would standing be relitigated? You can relitigate whether it's still in the child's best interest, but standing doesn't change based on that.
No?
I would argue with grandparent visitation, with the standing where it's circumstances show that conditions exist, which equity would see fit to intervene. Potentially.
Again, I agree with you that the analysis should be concerning what is in the best interest of the child.
Correct.
But if there has already been a determination that the grandparents have standing, and based on the facts here, it's clear that they should, then I don't understand why the issue of standing gets changed based on a subsequent order. So again, the subsequent order goes to the merits of what's in the child's best interest, not the issue of standing.
And the court also didn't say no visitation. He just said it couldn't go past supervised visitation. He didn't think it was in the best interest of the child for the maternal grandmother to have visits with the child unsupervised.
No, it's supervision, or excuse me,
Right.
visitation at all. Any visitation, supervised or unsupervised.
So maternal grandmother never had supervised visitation? The $65,000 that she said she spent?
Prior to the court's decision, on an interim basis, she did have supervised visitation.
And after his decision, he said no contact at all, not even supervised?
Correct.
Okay, thank you.
Thank you.
That's simply not true. He immediately, as I said, a few hours after the decision, he offered my husband and me 2 hours once a month supervised. And
That was your
Not the
son-in-law.
judge, that was your son-in-law.
Offered you.
Son-in-law,
Right.
yes. And we do have standing. Judge Clark Richardson actually fought. He was firm with Mr. Robert Wallach. Excuse me, I'm nervous. With Mr. Robert Wallach, and Mr. Wallach was saying, "Oh, I don't think they have," and he said, "I know they have standing." So that was absolutely, can you hear me?
Yes.
Absolutely not true. I was with my granddaughter from before she was born, taking my daughter to the doctors, seeing her pictures, and the 3 years and 3 months most important years of her life, according to the doctors. She begs at CFS to see me. She begged Jake Wartenberg to see me. She said, when will I see her? When will I see them, for me and my husband? And now she's saying things like to my daughter, I'm no good, I changed, I'm bad, I'm poop. I'm poop. This girl was always happy. I took her to ballet, preschool, play dates, the park, the museums, everywhere. She was a happy, thriving child. And when you take a child away from a family, even her little brother, the only thing worse than that, I think, is death. The doctors say that as a teenager, the way she's feeling now, she could easily start doing drugs, possibly suicide. And
I'm so sorry, ma'am. We're out of time, but we will look through your papers very closely.
please, thank you.
Thank you. Jobar Holding Corp. versus Halio. You may proceed.
Good afternoon, Your Honors. Dan Brescher for the plaintiffs, respondents, appellants. The defendant appellant doesn't seem to be here, his counsel. So I'll reduce some of my comments to point out that in the defendant appellant's briefs, he points out erroneously that Halio was not a director, whereas we allege in the complaint at paragraph 24 of the complaint that Halio was a director. And the defendant claims that Halio was not a salaried officer, whereas at page 5 of Halio's reply brief, he says that, but she claimed that she was entitled to salary. So this is relevant to the faithless employee claim.
And you're with which party? Defendant, appellate?
I'm representing the plaintiff's appellant, the
Okay, I
plaintiff's
thought you said
respondent
defendant.
appellant.
That's what
It got switched around because I appealed, but then he perfected. The Thurman and Eimer defendant claims that we lack standing to sue them, but if you look at the 11th cause of action, it's brought on behalf of the corporation, and the corporation certainly would have standing to sue its accountants. In addition to which, I would cite to the case law that says that where the accountants were directly involved in the fraudulent activities, participated in it actively and supported it, that a victim of that, who's not the corporation but is a shareholder, would have the right to go directly against the corporation, against the accountants. And as far as the statute of limitations goes, the continuing treatment theory would apply here, because it's the same acts, the same fraud with the tax return. If you look at Schedule L to the tax return, the accountants reported that the loans were by people other than shareholders, whereas the loans were all to Barbara Halio, the director and officer. And that's false reporting in the tax returns for the purpose of avoiding taxes, which, strangely, Mr. Yescu, the original attorney for Barbara Halio, admitted in his pleadings that's in the court record. So the tolling was, I think, an important aspect as well, because there was no way for my client to discover this fraud based on the fact that he was getting tax returns that indicated that third-party lenders had lent the money, and that there was $1 million or more in the corporation that was owed to it by third parties, not by Barbara Hallio. So he was shocked to learn in 2016 and 2017 that it was Barbara Hallio that had taken all the money, that she had spent all the money, which she admitted in phone conversations that are cited to the record. And so he brought the action for an accounting in 2016, got all the records, and then brought the action when he saw that she had taken the funds. If the court has any questions, I'll be glad to answer.
I think we're good. You'll have time, extra time on rebuttal.
I'll save it for rebuttal. Thank you.
Good afternoon, Your Honors, and may it please the Court. My name is Christopher Lyon of Goldberg Segala. I represent Terminen Eimer, LLP, with regard to this appeal. As Your Honors are familiar with the facts, I'll jump into the argument. We respectfully submit that the plaintiff abandoned the appeal from the dismissal of the 11th cause of action because that was dismissed based on statute of limitations. It was dismissed because it was time barred, and plaintiff's entire appellant submission, and not the reply, but their original appellate brief, does not address the timeliness issues. It does not argue that the court got anything wrong with regards to determining the statute of limitations. It does not.
Assuming that it's not time barred, would the derivative claim be able to proceed because it's properly, sufficiently pled?
Assuming that it is not time barred, Your Honor, the claim by Jobar is a derivative claim that could proceed against Terminen Eimer, LLP, if it were timely. But we're talking about something where the transfers of money occurred prior to December of 2013 in accordance with plaintiff's counsel's own admissions during oral argument of the motion to dismiss. And so we are talking—
Were there any things that occurred in 2015 to 2017? I thought that there was actions that were alleged to have occurred in those two particular years.
Nothing that would be causally related with the damages that are at issue in this case. The only damages that—
Adversary contends that there was some sort of continuing wrong occurring. How do you answer that?
You kept on, the firm kept on issuing reports saying everything was fine when it wasn't.
So actually what is alleged with regards to the tax returns is that the tax returns contained information saying that there were loans. And the plaintiff, disputes that they were loans and that the
K-1s that were filed in 2015 and falsely amended in 2017, and then the action brought in 2017, why isn't that timely on those particular allegations?
Of course, Your Honor. So because we're talking about what actually approximately caused the damages here, the filing of the tax returns or the issuance of the K-1s to Mr. Buck is not a source of act that can serve as an accrual for a cause of action.
Why?
With regard to Jobar.
Why?
Because Jobar knew. Jobar's agent, being Halio, was
I'm sorry. I get a pass because the person who's committing the fraud knew. Does that make sense to you?
Your Honor, it only makes sense in
That makes no sense. How does I don't understand. I really don't.
Of course, Your Honor.
You're saying that the person who is responsible for the fraud, their knowledge of their fraud somehow protects the company? I don't understand.
So, Your Honor, if I could just back up. So the 11th cause of action is a breach of the covenant of good faith and fair dealing with Jobar, not with Buck. What information was provided to Buck is not a trigger for a cause of action on behalf of Jobar. The damage that was done to Jobar—
The cause of action is brought derivatively for— He's a shareholder in Jobar, right?
Buck is a shareholder in Jobar, that's correct. So so Jobar was damaged at the time that the transfer actually occurred, not at the time that tax return documents were provided to Buck. And
Sounds like splitting hairs to me.
so, Your Honor, if I may only make one final point with
Please
regard
do.
to the remaining arguments. The fifth, seventh, and eighth causes of action, those were dismissed for lack of standing. The counsel relied in the entirety of the appellate argument on a case dealing with 1450 Broadway Associates that this court had decided in 2024. That case does not deal with the issues of standing or timeliness. It only has to do with whether the allegations were sufficiently pled.
And in fact, in that particular case, those similar allegations were brought derivatively, not necessarily individually.
That is correct.
So it's
And-
distinguishable on that particular.
I'm sorry?
Right. It would be distinguishable, that case, for this argument.
Yes, exactly.
Thank you.
Thank you.
And since you had a minute left over, you have 2 minutes now. Okay, you're done? Okay, thank you. People versus Robert Dancy. You may proceed.
Good afternoon, Your Honors. Rebecca Gannon of the Legal Aid Society on behalf of Mr. Robert Dancy. I'd like to start by addressing the introduction of the videotape statement in this case. This case was very unusual in that there were 3 moments in time that are relevant to the introduction of the video. First, when the police officer McBrown spoke to Mr. Dancy in the holding cell, that statement was suppressed because the people could not meet their burden that it was voluntary beyond a reasonable doubt because the officer could not recall everything he said to Mr. Dancy. The second moment is when Mr. Dancy refuses to speak to Detective Gutierrez, who comes.
And for context, the first statement happened 13 hours before the videotape statement.
Yes, it did, Your Honor. It happened at about, it happened at 8:50 a.m. and the videotape statement was about 3 p.m. But between the time when Mr. Dancy refuses to speak to Detective Gutierrez and he makes the videotape.
I thought that was at 8:50. I thought the refusal to the detective was in the morning at 8:50.
I'm sorry.
And the discussion with Officer Brown was shortly after the arrest at like 3 in the morning or something.
Correct. I think it's a little bit unclear what time, but you are absolutely correct that that is before and that Gutierrez speaking to him is at 8:50.
Okay.
So there's about 6 hours between him refusing to speak to Detective Gutierrez and the videotape statement.
Right.
The people and the hearing court below found that there was no evidence that there was any misconduct by the police that would show that the invocation of the right to remain silent was not scrupulously honored. But that's not the standard. The people have to show as an affirmative burden under Miranda and under Mosley that they scrupulously honored his invocation of his right to remain silent.
Well, they asked him if he wanted to go upstairs to speak to them, and he said no. And then hours later, they present, the district attorney is now involved, and that's when the video statement comes in.
And at a different location as well.
Correct, which goes to the attenuation. But here, because of he invoked as well, there both has to be attenuation and the people have to show they scrupulously honored the invocation. Simply a passage of time and a different location is
So
not.
what else was supposed to happen? I'm trying to understand. The case law seems to indicate that if there is a significant amount of passage of time between the invocation and the statement, and that the circumstances of the taking of the statement don't raise any other concerns, like an armed officer, the same officer who arrested you being armed and brings you to the next location, that kind of thing. So tell me, what was lacking in those 6 hours? What were they supposed to do in those 6 hours that would satisfy that?
Well, Your Honor, People v. Kolar from this court, which we cited to in the brief, I'm happy to give the cite again, but it's from this court in 2003 was instructive because in that case, the defendant invoked, the people called the officer who had spent time with the defendant when he was deciding to make a statement. The officer testified that he had not elicited any specific conversations about the case, but he had specifically engaged him in small talk in order to develop a rapport, and that with that rapport, then he might be led to change his mind.
But we don't have that here.
Right.
Because the people failed to call the person that was involved. And in this case, the court in Kolar, the court suppressed that statement because the officer that was involved in the change of mind.
Even if we agree with you that he equivocally invoked his right to remain silent, which is really questionable based upon the language that he used, 6 hours later, as my colleague pointed out, in a different location with now a prosecutor, why isn't that sufficient attenuation?
And am I understanding your argument that Detective Gutierrez would have had to come back to escort him to the DA's office in order to make this statement? In order to satisfy the test you think we should employ?
Or that the people would have needed to call Gutierrez for him to say what he did not say or may have said to the defendant?
No to both of those.
Okay.
Let me respond, and I will also address your point on attenuation, Your Honor. All they had to do is show what happened to decide to bring Mr. Dancy to the district attorney's office to make a statement. They said they don't recall who transported him. So it could have been Gutierrez if he transported him.
Well, he was taken to central booking.
Correct.
Right? And it was after being taken to central booking that he was taken upstairs to the videotape room to talk to the DA. So they have to literally bring a witness to explain to us why a defendant who is being held on a crime is taken to central booking?
No, Your Honor, but they do have to bring a witness to explain why a defendant who said he didn't want to speak is now being brought directly to the prosecutor's room to make a videotape statement. And the burden is small, to be clear, but the people here claim that they don't have any burden. And if I might just briefly respond to your point about I also want to be clear that the factors that go to attenuation, while they overlap with scrupulously honored, they're not coextensive. And the reason for that is once a defendant invokes the right to remain silent, the people have to make a showing that they have scrupulously honored, and that is an affirmative showing that they've essentially backed off in a way that's different than before a defendant invokes. It's a different standard. So I agree that it is relevant, the time period, the distance from all of that, but that's not the only answer. They have to make some showing. And if I might briefly just address your point about whether it's reviewable here because of whether
you can address that on rebuttal.
Okay, thank you, Your Honor.
Good afternoon, Your Honors. My name is Brian Wattoon. I represent the people in this case.
Is your adversary correct that once a defendant invokes their desire to not speak, no, I don't want to come talk to you, has now become, I'm exercising my right to remain silent, right? So what is required after a defendant says, no, I don't want to go talk to you?
The defense is correct that that right must be scrupulously honored, that invocation. I think the defense conflates two different burdens, though, and I think the case law is pretty clear about this. We, of course, did have the burden to show the voluntariness of the later videotape statement. That's why we showed attenuation. That's why we showed the Miranda warnings, which
So in
the defense
answer to
doesn't
my
challenge.
question, oh my God, I asked you what else had to happen for once a defendant says, I don't want to talk to you. So the answer is there has to be attenuation and a Miranda warning has to be given
Right.
that he relinquishes.
Yep. There
That's
has to be a definite pronounced break is the terminology in the case law, and a fresh set of Miranda advisements. And here we showed both. There was
All
6
right.
hours.
Does the case law say you have to bring the person who he said, I don't want to talk to you, back to establish now he wants to talk? Or
No.
he's willing to talk now?
No, it doesn't. Of course, it says the opposite and has said the opposite for decades, that the people are not required to bring in either that person or other officers who in the interim may have done things, for instance, like transport the defendant to central booking. In the
We have
absence
one
of a,
police officer who transport the defendant from the holding cell to central booking, and another officer who transports the defendant from central booking cell upstairs to the DA's office. Do we have to have both officers testify?
absolutely not. In the absence of a bona fide factual predicate shown by the defense that those officers have some testimony to give that bears on the issue of voluntariness, that's material to voluntariness. And here there was no such showing by the defense. So we proved the attenuation, we proved the fresh set of Miranda advisements, which are unchallenged, and
one last question. Once the ADA here on the video recording Mirandizes the defendant, correct?
that's right.
Does the defendant say anything at all, protest in any way that they don't want, that he doesn't want to talk? Why have I been brought up here? I didn't ask to be brought up here. Anything like that?
He does not.
Okay.
The last thing I would like to say before sitting down is just that any error in admission of this videotape statement or the DNA evidence that the Confrontation Clause issue is about would have been harmless in light of the surveillance video that really gets you 99% of the way there in this case, and the officer's testimony about what the surveillance video showed, which gets you the remaining 1%. If there are no further questions, I rest on the brief.
Thank you. Counsel?
Just to address the reviewability of the videotape statement issue, it is correct that the hearing court here assumed that Mr. Dancy invoked his right to remain silent in order to reach the question of whether it was scrupulously honored. However, under the CPL provisions and La Fontaine and Concepcion make clear, this court can't affirm on a ruling that was not adverse to Mr. Dancy below. So at minimum, it was not decided upon in order to reach the final issue, or it was in his favor. So in either way, finding the court doesn't have it properly before it to find that it wasn't a proper invocation. The court went past that issue.
Do you want to deal with counsel's argument that even if this statement was admitted in error, the evidence here was so overwhelming that it would be harmless?
It's not harmless beyond a reasonable doubt, which is the standard here, because first of all, it also was introduced, it was played yet again by the prosecutor in summation. He realized there are significant holes in his case. Confession evidence is also the strongest possible evidence that can be presented to a jury, and the jury asked to play it again during their own deliberations. If they were so convinced this case was such a slam dunk, as the prosecutor contends, then all of those things wouldn't have happened. This would have been—
No, that's not necessarily true. I find that jurors are very, very thoughtful, and they want to heed to the judge's admonitions to review all the evidence, et cetera, et cetera. So the fact that they review everything doesn't mean that they didn't think that that videotape, which clearly shows a open container and everything that followed. I mean, the evidence is pretty clear. Your client was barely able to stand on his feet for any significant period of time without wobbling.
That very well is relevant to the initial stop of the open container, but would not be a slam dunk for the gun possession part. And that, like I said, the jury did request it again, which shows that, yes, they were thoughtful, but they were specifically thoughtful about this compelling piece of evidence.
Okay, thank you. Brazil versus New York State Office of People with Disabilities.
Good afternoon.
Good afternoon.
Stephen Klepfer for petitioners appellants Elijah and Melanie Brazil. Petitioners assert 4 claims. First, that an executive agency has no lawful authority to oust the Supreme Court's statutory Article 78 jurisdiction and to negate a party's statutory rights to file an Article 78 petition under Section 22 of the Social Services Law after a final agency determination simply by sending a reopening letter to petitioners after the Article 78 proceeding has already been duly commenced, which is what happened here. Second, yes.
Isn't there maybe some carve-out there where there's an express statutory or regulatory authority permitting such an action?
Yes, Your Honor.
And don't we have that in this case?
We do not, Your Honor. That is a Department of Health regulation which says that the commissioner may reopen a fair hearing record. It does not say the commissioner may reopen a fair hearing record after an Article 78 proceeding has been duly commenced. If that were so, and the regulation were held to mean that, that would mean that at any time, even after affirmance by this court of a favorable ruling under Article...
No, now you're adding an extra fact. Affirmance by this court. That's different, right?
Indeed.
Because now an appeal has happened and a court has made a determination. So please don't add that, because that's not what we have here, and that changes the calculus completely, right?
That's
so
fair,
the
Your Honor.
statute, as my colleague has said, does seem to allow for a reopening of the hearing.
It does, Your
So
Honor.
I may not like it, but the statute seems to say that.
First of all, it's not the statute that says that. It's a regulation of the Commission of...
Regulation, corrected. It
which
says
is-
it, though.
Which is significant. And it cannot be that the statutory right of a Article 78 petitioner, having received a final agency determination, having not requested to reopen that fair hearing, having not received...
I understand, but the regulation doesn't say the commission can reopen if the petitioner asks for it. It just says it can reopen.
That's true, and our argument on that stands and falls, Your Honor, on the concept that the filing of a timely Article 78 petition is a jurisdictional sliding doors moment where the jurisdiction of the administrative agency slides.
Do you have any court that has so held that we can sink our teeth into?
Oh, we did submit cases law on, not entirely in the Article 78 context, admittedly. I don't think, there's no case law which says this, because I don't believe any agency has had the temerity to try to reopen and seek a new merits determination on their fair hearing after an Article 78 proceeding has been filed. And so I cannot point you to a direct authority. What I can say is that all of the authorities that were enlisted in support of the government or the state's argument that this is okay were cases in which the reopening, sua sponte, happened before the Article 78 proceeding was commenced. And there is no case which says that under Article 78, Section 22, all your rights are a nullity. It's as if there was no final...
But it's not that all your rights are a nullity. Look, again, I may not like the way this has turned out, okay? I may, in fact, be offended by how this has turned out. But as the court, I can't be guided by my being offended. I have to be guided by what the regulations and the statutes say.
I would take a different view, Your Honor, and say you and your panel of colleagues need to be guided by what the statutes say. The statute, Article 78 and Section 22 of the Social Services Law, says that my clients have a right to file an Article 78 petition after a concededly final agency determination, and at that point, the agency cannot have jurisdiction at the same time that the court does. The court now, you know, as one of the cases in an analogous context said, that filing of the Article 78 petition, or that filing of the court action, takes away the authority of the agency to deal with the same matter, because it's the same matter we're dealing with, until a court says it's okay to go back to the...
Except that in this case, there is a specific regulation that permits them to reopen the fair hearing.
That is true, Your Honor. It does not say, as other regulations do say with other agencies, that only works before an Article 78 proceeding has been filed. But I would say that regulation cannot be read consistently with a petitioner's right, statutory right, to file an Article 78 petition pursuant to Section 22 of the Social Services Law. Otherwise, there would be basically constant administrative, regurgitation of these, and you'd never get to court. Every time, what happened here is we filed our.
I think that you're actually making the point, counsel, because where that might exist in other regulations or where it might not exist, here it specifically says that, and we have case law that interprets it, that if the authority lies that they can reopen the hearing, they're allowed to do that.
No, Your Honor, with respect, there is no case cited by the state or that we found or that I believe exists which says that following the timely filing of a Article 78 petition in circumstances in which the state or the agency.
I don't know. I think there's been cases out of the 3rd Department, out of this department, that actually do say that.
But you'll have time on rebuttal.
Thank you, Your Honor.
Good afternoon, and may it please this court. Anthony Radawatso on behalf of the state respondents. This court should affirm the dismissal of EB's petition as moot and for failure to exhaust administrative remedies.
Well, to be fair,
Yeah.
she went through she went through the administrative part. You guys denied her, so she filed an Article 78. That's usually how that happens. Then, in hindsight, we made a mistake. In fact, we weren't supposed to do that. And now come back here while her Article 78 is pending. She did what she was supposed to do.
She did what she was supposed to do in the first instance, Your Honor. That is correct. Well, that is as to pursuing the reimbursement claim for the back pay for those classes. There's a separate issue whether all of these other constitutional claims, those were never raised in the initial.
But they will be now.
But
they will be now.
That's
okay,
correct.
so I want to be real clear,
Yes.
right? That because it seems to me that in your brief, you attempt, the agency, I don't mean you personally,
Yes.
the agency attempts to narrow the scope of what will be determined in another hearing, okay? And as far as I'm concerned, it's not just what you think should be determined, but all of the issues being raised, because this family has been put through the ringer for something they were entitled to for I don't know how long, right? She should continue to fight to get reimbursed for something that had been approved, et cetera, and under some machination. No, don't do it over here, do it over there.
These channels for administrative relief are still available to EB. Just to be clear.
Just not the ones she wants.
No, that's not correct. EB has so there was a rescheduled fair hearing that was scheduled for May 2024 of this year. EB's mother did not attend that, but she does have a year to reinitiate that fair hearing. We do not object to her doing so. So she has until May 2025 to do that.
And all the while, the child who had the services now either doesn't have them or the mother has to go out of pocket and continue to
It's outrageous.
go around this merry-go-round.
That is not correct either, Your Honor. She was not denied eligibility for classes. She did obtain reimbursement for other community classes. She was denied.
But the specific one that she requested, she was denied, where other people in her same position were granted repayment for those specific classes.
She was denied.
The Office of People with Developmental Disabilities should not have to be lectured about how devastating it is to a special needs child, an autistic child. Change is hard for autistic children. So, you can get art classes somewhere else is not a solution for a family of an autistic child. They are not like the rest of us. They don't adapt so quickly. So this action that seems just like a little paper thing to the agency is a devastating thing to these families.
Your Honor,
it is outrageous.
I do not disagree with you at all.
I'm glad you don't disagree with me, and I hope that your advocacy then pushes your side to do the right thing here. They should not be put through more years of going after $3,000. It's outrageous.
You're right, Your Honor, and that is why OTDA in this case reopened the fair hearing process. That avenue for administrative relief is still available, and I do want to address my colleague's point here that this is something that doesn't happen that frequently or ever. As Your Honors mentioned, OTDA has specific regulatory authority to reopen a fair hearing sua sponte. That authority is not limited in any way by the commencement of an Article 78 proceeding.
What they don't have authority to do is divest itself of its authority and give it to another group. That's what you don't have an authority to do, but that's what was done here to deny this family a hearing for how long?
That actually isn't true, Your Honor. So this court, there are numerous.
You didn't deny the hearing?
Oh, I'm sorry. The initial ALJ did deny a hearing in this case.
And she had to file an Article 78 for you to reopen it and say you have a right to a
No,
hearing.
OTDA is a separate agency which runs the fair hearing process. They determined that there was jurisdiction to resolve this reimbursement decision in this case. They're entirely separate from my clients in this case, OPWDD and DOH. So, but to be
I'm
clear-
talking about the agency's permitting the fiscal intermediary to make decisions that lies with the agency.
Yes, and this is
They are not authorized to do that. They can give you a suggestion, they can give you their opinion, but the decision has to come from the agency.
Right.
You cannot divest yourself of that.
Well, 2 points, Your Honor, on that. There is specific authority for this delegation. It is in the HSBC waiver, which is approved by federal authorities every single year. It is also in Mental Hygiene Law 17.13c, where this delegation is permitted. But that said, there does, as you're pointing out, there does have to be reasonable supervision of the fiscal intermediaries, and there is that here. OTDA determined that, again, there is
After the denials. So
correct.
there wasn't initially. Because for how long did she ask for a hearing and was told, no, they made a decision. You don't even have a right to a hearing.
But the issue
You don't have a right to contest the finding.
And OTDA reversed that decision, and my clients, OPWDD and DOH, are committed to following those jurisdictional decisions as they have to do. But
Is the hearing scheduled?
it was scheduled for May 2024. Counsel for EB declined to participate in that. EB's mother declined to participate in that. But again, they do have another year until May 2025 to reinitiate that reopened second fair hearing. She can pursue her claims in that process.
Thank you.
Thank you.
Your Honor,
Don't allow that time to lapse, okay?
I will not, Your Honor.
All right.
On the threshold issue of whether this court has jurisdiction to hear these claims, I just cite you two, admittedly not First Department decisions, but two highly relevant and I would argue persuasive decisions. One is Rockland versus Coleman, 112 AD 2D 591. Once an Article 78 proceeding has been commenced, and that's mine, that's not the court's, jurisdiction of the matter reposes in the courts, and administrative agencies are, quote, not at liberty, unilaterally and without court sanction to reconvene the matter. The second one is also from the Third Circuit, I believe. Preston v. Coughlin, 164 AD 2D 101, Third Department, 1990. Once the administrative process has been exhausted, the matter is then ripe for review. Now, those were not Article 78 proceedings. Those were proceedings when a notice of appeal had been filed and the administrative agency charged forward with the administrative proceeding, and the court said, wait a minute, a notice of appeal has been filed. You don't have jurisdiction anymore. We have it. It's plain to petitioners, at least, that the same analogy applies to Article 78. Once a timely, uncontested Article 78 petition has been filed, the agency needs to stand down until a court says that it's done with it. We had a right to the Supreme Court's judicial review of this final agency determination, and that right cannot be negated by a unilateral act after the 78 petition has been filed by the agency whose final agency determination we're seeking judicial review of. That is our position. Thank you.
Thank you so much. Edwards versus Rockland Hospital. You may proceed, sir.
Thank you very much. Good afternoon, Your Honors. May it please the court. My name is David Weissman for the plaintiff appellant. The lower court committed reversible error on 3 issues here in this case. Number 1, the court completely ignored the testimony of the plaintiff in regards to the description of the ice patch and also in terms of the length of time in between the last snowfall and the occurrence of this incident. That's the first issue. The second issue is the fact that the court completely rejected the expert affidavit and claimed that and asserted that it was unfounded, speculative, despite the fact that the affidavit was based on meteorological data and again on the testimony of the plaintiff. The court stated that it was the defendant's testimonies was personal knowledge and the expert was speculative. But
Would
in what way?
Would that expert have known what amount of salt would be sufficient and in regards to the temperature to prevent freezing?
Well, I mean,
That's something within that meteorologist's purview?
not in terms of how much salt, no, but it seems like that would be something that a snow removal company should know, how much salt would be necessary based on the fact of what the meteorological expert, Mr. Wright, does know is the likelihood of approximately how much snow, or I should say slush, was present at the time. And based on that, it's the snow removal company that should have known how much ice it would, salt it would have taken to get rid of it. It may have needed to actually remove the patch. I think the point is here is that there's a reasonable inference that a patch had remained, that due to their activities, there was a patch that was either compressed, carved out, and that created, that became slush, therefore, because of the shape and design of that. And the change in temperature turned that slush into ice, and that's something that should have been anticipated by the defendants, and that should be deemed an exacerbation of the condition. The slush itself is a form of the beginning of the exacerbation because the snow doesn't turn into ice. The fact that it became slush due to the activities of the snow removal company created the situation
You had
in which
somebody from the snow removal company who detailed, their actions and what they took to remove the snow, and no one called them back after they had completed their job. I'm just wondering, so it was their motion, they met their burden. What was submitted besides the meteorological data?
Well, first of all, the case law is that the plaintiff's testimony alone is sufficient to create a question of fact as to a dangerous icy condition that's visible and apparent, and based on, it's undisputable that there was a snowstorm.
Why?
a
She
few
didn't
days
see it before she fell?
No.
So
That might
if
be
she
true.
didn't see it before she fell, why should anyone else have seen it before then?
Because this is summary judgment, and the fact of the matter is her
I'm
testimony...
sorry, that's not an answer because this is summary judgment.
No, well, what I mean to say is, she makes 2 different statements. One is that initially she doesn't see any snow or ice, which is actually no different than testimonies in almost all types of personal injury cases in which initially as they're walking, they don't see a dangerous condition and they only see it after they fall. It's very similar here. She's driving into the parking lot, she doesn't see any icy condition. After she falls, she sees the icy condition.
Okay.
The icy condition she describes is such a type that's visible and apparent. It's 2 feet by 2 feet, 1/4 inch thick. It's a significant condition. We can get into comparative, she should have seen it or not. We can also get into her credibility, which is true, the first statement, but those are issues for the jury. That's what I meant, this is on summary judgment. Those are jury-related issues. As far as the strength of the defendant's testimony, first of all, I think that there are certain holes in their prima facie case, but leaving that aside, there still is a question of fact here. In between, you have an expert, you have meteorological data, and again, you have actually case law, the Gannon case that I quote in my papers, and several other cases in which simply alone, in terms of constructive notice, if the plaintiff testifies as to a significantly size of visible and apparent icy condition, and we know there was a snowfall a few days before. In fact, that case, the snowfall was 6 days before. And the icy condition was I think it was a little thicker, but it wasn't of a much greater size. And the court said that was create a question of fact as a constructive notice.
All right, you'll have time on rebuttal.
May it please the court, David Rutherford, I represent defendant respondent at Rockland Hospital. The defendant, actually both defendant respondents, made out a prima facie case. The prima facie case was that they didn't create the condition, nor did they have actual or constructive notice. Now here, we had a snowfall that stopped, by all accounts, at 4:15 in the morning on the 4th of March. 8 hours later, which would have been about between noon and 1 p.m., the snow removal contractor went onto the premises and checked, and there was no ice.
Now, admittedly, at the time that they checked, it was over 32 degrees outside, so there would not have been freezing conditions.
That's fine, but there's no ice the day before, okay? None. That's uncontested.
Okay, do they say there's no water on the ground?
They don't say that, but there's no evidence that there's, so what? If there's water on the ground.
So what? If there's water on the ground and it goes under 32 degrees, water freezes under 32 degrees. So that's the so what?
Well, water on the ground is not a defective condition in and of itself. It's not. Okay?
If it's water on the ground that's left over from snow that's dripping off, it might be.
There's no evidence of that.
That's what I'm asking, counsel. I'm not against you.
No.
I'm testing you, okay? So you don't have to attack the court.
I'm not attacking the
Okay?
court. I'm not.
All right.
The whole plaintiff's expert opinion is based upon facts that are purely speculative. We've got a meteorologist, and a meteorologist is qualified to talk about what the temperature was, what the snowfall conditions were. He goes on to speculate, and this is total speculation, that there was a patch of snow that the snow contractor missed that turned to slush. There's no evidence of that. None whatsoever.
Does the plaintiff even describe slush as she gets out of the car?
No.
Anywhere in the parking lot?
Never in the record is slush present. That is a total, first of all, he's not qualified to do that, but second of all, he has to have evidence in which to rely on, and there's no evidence of
He
that.
says the defendants used too little salt. He doesn't give us the basis for that.
He has no qualifications to do that. First of all, there's no evidence as to how much salt was used, and even if there was, he can't testify as to that. He can't testify as to a patch of snow that was turned into slush because there's no evidence of that. So what happens is, overnight, okay, somehow a patch of ice comes up. She comes at 7:30 in the morning before our guy gets there, and the testimony is our guy gets there and he checks every day at 8 a.m., and if there's ice present, he would take care of it. She falls at 7:30. We didn't have enough time to discover the ice which came overnight and rectify it.
Thank you.
May it please the court, Roland Koch for the respondent, Floss Group and Ecoscape. The number one statement for the expert here is just an absolute fabrication in terms of stating as fact with no basis anywhere at all to say that what the plaintiff slipped on was in fact a patch of ice, a patch of snow that my clients didn't clear, that they didn't salt, that the co-defendant didn't notice despite checking every day, my client coming back in the afternoon when it's warm and didn't miss this giant patch of snow slush that then later melted into water and then became ice, presumably over the evening. That's utterly speculative. There's no basis to in hindsight say that was the source of the water that ultimately apparently created this ice patch. And there's case law after case law after case law from this court and just as many from the second department, which I can run through there in the brief, Montiel, Rios, Ramolas, and this court has also said the mere presence of ice is not negligence.
That's exactly what plaintiff is arguing. He's arguing there's ice. Somebody was negligent. It must be the snow contractor. It must be the property owner. It doesn't work that way. That's not how this court rules, and that's in Lenti. And based on that, the court properly dismissed the complaint. Thank you.
Thank you. Counsel?
Where do I start? First and foremost, I don't see this is every single case in which you have summary judgment. All the defendants are saying is they make out their prima facie case. They have testimony of their witnesses saying, we checked, there was nothing there. That's every single case of prima facie with summary judgment. Otherwise, they can't bring the motion. They don't have prima facie evidence. So that's number one. And in this case, you have the plaintiff's testimony as to the description of the condition. Now, there's two different theories here. There's the theory in regard to the landowner who has to do with constructive notice. For a constructive notice, her testimony and the time lapse in between when the last snowfall was and when she found the ice patch is sufficient to say, where did this ice come from? Members of the court, if you see an ice patch on the ground in the wintertime, there was a snowfall 2 days before, what is the normal assumption? And it's left over from the snowfall. It's not that someone spilled, I don't know, is there seltzer there or something? I mean, that's very outlandish on what the suggestion is being made here by defense counsel. So in terms of constructive notice, to say this is speculation, this is something from out of this world, UFOs. I mean, I think there's a reasonable inference, and that is sufficient on summary judgment to say that a condition of this size and looking at the proximity to the storm that was left over from the storm. So that's as far as the landowner goes. And yes, he's testified that he only said, by the way, he's never had any personal testimony that he checked the day before or after the inspection. Mr. Walsh, who was the witness for the landowner, he says, yes, usually after inspection, he goes and checks. Here, he was silent. No personal knowledge as to whether he inspected, he didn't remember. All he did testify to was that was regular practice to check. So why didn't he check and why didn't he clean it up in that case? I mean, there's at least a question of fact as to that, as why didn't that happen? That's constructive notice. The other issue has to do with the case law of the snow removal company. Yeah, there are cases that say that the mere presence of ice and snow is insufficient. Of course, because there you have to prove that there's an affirmative act that takes place, and that's where the expert comes in order to show that this is an exacerbation because the ice was first snow, this is ice, and that developed from the compression that developed from leaving a small...
Thank you.
You're welcome. Thank you.
Lee versus Grimalt.
Good afternoon, Your Honors. Thank you for waiting for me, and may it please the court. My name is John Cahill. I'm here on behalf of the Appellant, which is an art gallery in New York City that bought an artwork, a sculpture, that was owned by the plaintiff's mother, and the plaintiff brought a lawsuit. She lives in New York. She brought a lawsuit saying the artwork was stolen by my client in a conspiracy with other people.
And the record below included documentary evidence showing that the consignment was done while the decedent was still alive at her behest and was sold during her lifetime.
Correct. And the court below dismissed the case, dismissed all the claims. The plaintiff appealed. This court affirmed, and the claim she made that the artwork should be returned to her mother's estate is gone. And what she's done instead is she's filed the exact same case in France.
In France.
And what we are here asking is for some help for the lower court, who in their decision, and understandably, was concerned about saying, I don't want to tell a French court what to do. And we didn't ask for that, and we're not asking this court for that. We're just asking the court to issue an order to a person who's in its jurisdiction. And that's what this is for. And it's good law and it's good policy also not to have a French court do it. And that's really all I had to say. Unless you have questions. Okay.
We got it.
Yep. So.
Thank you.
I'm the only one. May I just say, since I've been in court a lot this week, that without saying too much of anything, but in troubled terms, it's actually, I want to bring the country into courtrooms to hear, because I said, this is where you see people take this seriously. And I'm just was moved by it today for whatever reason.
Thank you so
By
much
all of
for
you.
that. Have a happy holiday. We don't get that often, so thank you.
It's for real.
This court is now adjourned until tomorrow at 2 p.m. Main stand.
Okay, thank you, officer.